ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಡಿಬಲ್ ಇದೆ ಅಲ್ಲ? Just the last one. Stainless steel. ಯಾವ್ದ್ರಲ್ಲಿ? ಇದು ನಂಬರ್ 10.2 ನಲ್ಲ ಐಗೆ 2 of 24 or 5 by litigant ಅಂತ ನಾಳೆ ಆಗ್ತದೆ ಅವರು ಮನೆಗೆ ಸಿಕ್ಕಿಲ್ಲ ಅಂದಾಗ ನಂಬ್ತಾರಲ್ಲ ಅದಾಗ ಕಂಪ್ಲೇಂಟ್ ಆಗಿರ್ತದೆ. ಈದಿಗೆ ಸಿಗಲ್ಲ, ಅಲ್ಲಿಗೆ ಸಿಗೋವರೆಗೂ ಮೆಮೋ ಬಂದು ಸಾಯೋ ಬಂದಿದ್ರ ಅಂದ್ರೆ ನಾವು second set will be furnished. ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ. ಹಾ ಮೊನ್ನೆ ಯಾವ್ದೋ ಬಂದಿತ್ತು ಅದು, ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ ತಕ್ಷಣ ನೆಕ್ಸ್ಟ್ ಡೇನೇ ಬಂದಿತ್ತು. ಒಂದ್ಸಲ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಡಿ ಸರ್. ಹಾ ಏನಂತ ರೀಸನ್ ಹೇಳಿದ್ರಿ ಹೇಳಿ, ರೀಸನ್ ಏನ್ ಹೇಳಿದ್ರು? ಹಾ ಇವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಇತ್ತಾ? ಹಾ ನಾಳೆ ಹಾಕ್ಲಾ? ತಗೊಂಡೋಗ್ಬಿಡಿ. ಹಾ ನೀವೇ ತಗೊಂಡೋಗ್ಬಿಟ್ರಿ. ಅದು ನೋಡ್ತಾ ಇದೀನಿ ಸರ್, ಸೆಕೆಂಡ್ ಸೆಟ್ ಸರ್ ಹೇಳಿ. ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಅವಕ್ಕದು ಡೇಟ್ಸ್ ಬೇಕಂದ್ರೆ ಸಾಹೇಬ್ ಕೇಳ್ಬಿಡಿ. ಹಿಂಗ್ ಕೊಟ್ಬಿಟ್ರೆ ಪೆಂಡಿಂಗ್ ಸ್ಕೂಟಿ ಅಂತ ಬರೀಬೇಕಲ್ಲ. ಬರೀರಿ ಸರ್. ಫ್ರೆಶ್ ಅಂದ್ರೆ ಸ್ಕೂಟ್ನಿ ಬ್ರಾಂಚ್ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಬರೀರಿ ಸರ್. ಡೇಟ್ ಬೇಕಂದ್ರೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಇಲ್ಲಿ ಇದೆ ಸರ್, ಆದ್ರೆ ಎಲಿಜಿಬಲ್ ಇಲ್ಲ. ಸ್ಕ್ರೂಟ್ನಿ ಸ್ಕ್ರೂಟ್ನಿ ಅಂದ್ರೆ ಸ್ಕ್ರೂಟ್ನಿಗೆ ಕಳಿಸ್ತೀವಿ ನಾವು. ಸ್ಕ್ರೂಟ್ನಿ ಇರ್ಲಿ ಸರ್, ಎಲ್ಲ ಬರುತ್ತೆ. ನೀವು ಫಾಲೋ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಇವತ್ತು ಟ್ಯೂಸ್ಡೇ ಅಲ್ವಾ, ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ ನೀವು ಹೋದ್ರೆ. ಪಾಠ ರೀಚ್ ಆಗ್ಬಿಟ್ರೆ ಆಗುತ್ತೆ. ಇಲ್ಲ ಅಂತಂದ್ರೆ ಮಧ್ಯಾಹ್ನ ಅದೊಂದು ಆಗುತ್ತೆ. ಮಧ್ಯಾಹ್ನ ಅದು ಮ್ಯಾಟ್ರಸ್ ಹೆವಿ ಮ್ಯಾಟರ್. ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕಳಿಸ್ರಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡ್ಬಿಟ್ಟು ಕಳಿಸಿ ಎಲ್ಲ. ಅಂತದು ಹೋಗಲ್ಲ, ಇಸ್ಕೊಂಡ್ಬಿಡ್ಬೇಕು ಸುಮ್ಮನೆ. 2368. ಸೆಪ್ಟೆಂಬರ್ ಅಂದ್ರೆ ಸೆಪ್ಟೆಂಬರ್ ಹೋಗ್ಬೇಕು ಬ್ರಾಂಚ್ ಅವು ಹೋಗ್ತಿಲ್ಲ ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ ಇದೀವಿ ಅಂತ ಪ್ರಿನ್ಸಿಪಲ್ ನಾವು ಸ್ವಲ್ಪ ಟೈಮ್ ಇದಕ್ಕೇನು ಬರ್ತಾ ಇರ್ಬೇಕ್ರೆ. ಅದಕ್ಕೆ ನಾವೇ ಮಾತಾಡೋಣ. ಸ್ಕೂಟ್ನಿ ಮಾಡ್ಬೋದಾ? ಬರೋಲ್ಲ.
It's an RFA pertaining to the implementation of a foreign judgment, and by
How year?
2015 RFA.
15.
And the matter has already been partly heard by your lords earlier, and it was released from Parted. It was released from Parted since you were shifting to the Harvard bench, and my senior had already argued half the matter. It may be taken up for
January. 2013 ಮಾಡ್ತಾ ಇದೀವಿ. ಹಿಂಗಾಗಿ ಅಷ್ಟೇ. ಒಂದ್ ಸ್ವಲ್ಪ ಒಂದ್ 2-3 weeks ನಾವು RFA ಮಾಡಿದ್ವಿ ಅಂದ್ರೆ ಬೇರೆ ಗೊತ್ತಾಗ. I start reading a lot of civil law now to understand RFA, RSA ಇವೆಲ್ಲ ಗೊತ್ತಾಗಬೇಕಲ್ಲ. ಹಂಗೆ
ಒಂದು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಲಾಸ್ಟ್ ವೀಕ್ ತಾವು ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಜಾರಿ ಆಗಿದೆ. Day after tomorrow. Now I sought for an interim order. Allegation is against principal. Punishment is given to me. Day after tomorrow. KAT matter.
Next week. ಏನ್ ಅರ್ಜೆಂಟ್? ಪ್ರಮೋಷನ್ ಎಲ್ಲ ಹೂ ಟ್ರೀಟ್ಸ್ ಪ್ರಮೋಷನ್ ಆಸ್ ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಅಂತ ಕೇಳಿ ಸರ್ವಿಸ್ ಲಾಯರ್ಸ್ ಇಷ್ಟು ಜನ ಇದ್ದಾರೆ ಇಲ್ಲಿ. ಯಾರು ಪ್ರಮೋಷನ್ ಮ್ಯಾಟರ್ಸ್ ಅನ್ನ ಜನರಲಿ ದೇ ಆರ್ ನಾಟ್ ಟ್ರೀಟೆಡ್ ಆಸ್ ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್. ವೀಕ್ ಆಫ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಫ್ ಆಲ್
12 and 13. They are
12, 13.
Yes, Lord.
ಯಾವ ಇಯರ್?
2014 matters.
14
They're likely to be settled. We are speaking, in fact, we'll report the settlement.
ಯು ಆರ್ ರಿಪೋರ್ಟಿಂಗ್
4 weeks, yes, 4 weeks.
ಯಾವುದು?
Are they same eitherly? Same. Other 12 and 13 ali. She represents the respondents. I am for the appellant.
It is submitted at the bar that there is possibility of amicable settlement and therefore some time be granted. First stop. All after 4 weeks.
Much of this.
Yes.
One matter for
12-13 ಎರಡು. Connected another. Same judgment. Call along with each other. Okay.
One matter for tomorrow for this reason. But right from 1999 to 2023 senior at least I am above. Now, my lord, in the impugned senior at least I have been pushed down and private respondents have been pushed down.
Pushed down, correct. Urgency. ಅದರಿಂದ ಏನಾಗ್ತದೆ?
Day after tomorrow is the DPC, my lord. They will be promoted to the post of assistant controller.
ಈಗ ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೆ ನಿಮ್ಮ ಏನು ಅದೇನು ವಿಶೇಷ ಇಲ್ಲ. ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಬರ್.
Item number
ಹೇಳಿ.
A writ petition, my lord, of year of 2017. I am the auction purchaser, my lord. DRAT pass an order in favor of me. My lord, the stay is operating from my lord.
Week after next.
On date.
Week after next ಬರುತ್ತೆ.
25 serial number 25.
25.
10 days time.
10 days. 24 matter.
25.
25 matter.
Appear for appellant.
All right. ಅದೇನು ಡೇಟ್ ಯಾಕೆ ಕೊಟ್ಟಿದ್ರು?
ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ಅದು ಪೋಸ್ಟ್ ಆಗೋದಿಲ್ಲ ಅಂತ.
All right. After 2 weeks.
10 days.
10 days.
2 weeks ಮೇಲೆ ಒಂದು ಡೇಟ್.
2 weeks ಅಂತ.
Serial number 21, my lord.
ಅಲ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಅಂತ ಬರ್ಕೋಬೇಕು.
Serial number 21. I pray for short accommodation.
21.
21. And 37 also.
21 and 37. ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ?
I have contacted them, my lords. They have
No,
not.
37 is 2018 matter.
18.
I have read the papers.
It's kindly short date.
After 2 weeks, it's a request of 3 weeks.
Lordships, kindly, my lord, one submission, my lord. Serial
Yes.
number 22, my lord, some proxy counsel for the advocate on record. He is unwell today, my lords. Kindly be taken up next week, please.
22.
22, please, my lords. For Pratik Chandramouli, my lords.
All right. Ajahn bhai. ಮಾಡ್ಬೋದಾ? ಅಲ್ಲ ಕರೆಕ್ಟ್, ನಾವೇನು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಟ್ಟಿವೇನು ಇಲ್ಲಿ? ಇಲ್ಲ. 2 weeks ಆದ್ಮೇಲೆ he is not well. Ajahn bhai 2 weeks on health ground of arguing counsel.
Obliged, my lords.
Serial number 38, my lord.
28.
38.
38.
There are 2 matters. I am appearing for the petitioners.
ಇದನ್ನು ಓದೇವು ನಾವು.
And Mr. Holla is appearing for the respondent. I need some short accommodation, my lord.
ಕೊಡ್ಬೋದಾ? In the first week of January. Okay.
Obliged.
At the request of. Okay. Order seal number 1, Nataraj Ballard.
I appear for the appellant, my lord. Second set
Nataraj.
has to be, yes, my lord, second set has to be filed by the respondent. If they file it, my lord, I'll argue next week itself. my lord.
I'll be filing during the course of the day, my lord.
Filing your objections.
No, she has filed it, my lord, and one copy, I mean, only one set has been filed. That is why office has raised an objection. That is why she has to file the second set.
I'll furnish it during the course of the day, my lord.
Memo accepted. Office objection.
Second set illa andre.
Office objection to be addressed within 1 week. Call after 2 weeks.
Much
Oblige.
Seal number 2, Shantaraju.
Lord, I am for the petitioner mail.
Yes, Shantaraju.
There was an objections, my lord, that is the directions given to the government, that AGA on 22/9/2022, my lord. It is a premature transfer, my lord, wherein the records are to be produced, directed to produce the record. So either they are not produced, my lord. On 22/9/2022, my lord, the directions was given, my lord.
Brother, Madam,
Communication is gone from our office.
Coordinate bench has ordered, government advocate shall mandatorily comply with the order dated 11/25.
Concerned department.
ಯಾರು ಕೊಡ್ಬೇಕು ಹೇಳಿ.
Either to 25 adjournment have they gone taken, my lord, to produce the records.
Last night I have been in touch with the concerned.
ಅಲ್ಲ ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಈಗ ನಾವು ಆರ್ಡರ್ ಮಾಡೋಣ ಬರ್ಲಿಕ್ಕೆ.
Director Karnataka State Audit and Accounts Department. They are naming each other audit department.
A coordinate bench of this court wide order dated 11/1/2023 had said as under. First, another coordinate bench of this court wide order dated 1/2/2023 has said as under, as follows. First off, the said order, despite the principal order, despite warning by the coordinate bench, is not being complied with. First off, no symptoms of immediate compliance.
But she can move
forthcoming.
that action for honorable arbitrator. That's the matter.
Next paragraph, in view of the above. Yaroru, enta director.
Karnataka State Audit and Accounts.
Norma, Principal Director, Karnataka State Audit and Accounts Department, Department.
Principal Secretary, Department of Health and Family Welfare.
No.
And Alkinta Madle, Principal
Finance
Secretary, Department of
Finance department, my lord.
Department of Finance,
Yes, my lord.
Department of Finance shall immediately furnish the required information to the AGA and send a compliance report to the Registrar General of this court within 10 days, failing which they shall personally appear on the next date of hearing for facing suitable action at the hands of this court. First, call this matter on 2 weeks on date. First, registry to send a copy of this order to the aforesaid officials by speed post before sunset of the day. Okay, it will come. No, they will not obey that. I was also a government advocate. Now we know those people.
Date, please.
19th of November.
19th November.
Seal number 3, Nitin Ramesh.
My lord, I will file my objections to the vacating stay, my lord. It may be posted for final disposal, my lord, or hearing, my lord.
Second week of hearing hakona, second week
Please,
nalli.
please.
Second week of January. ಅದು ಉಪೇಕ್ಷ ಮೈಕ್ ಅನ್ನು ಉಪೇಕ್ಷ ಮೊದಲೇ ವೀಕ್ ಇರ್ತದೆ ಕೇಸ್ ವೀಕ್ ವಾಯ್ಸ್ ವೀಕ್ ತಳಿ ಯೂಸ್ ದ ಮೈಕ್ ಹೇಳಿ.
Office objections were not complied by the petitioner. Therefore, the matter was listed again and again for the orders.
No, my lord, in the course of the day.
Last occasions also time was granted, my lord.
ಏನು ಆಫೀಸ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ being insignificant is overruled. Not necessary. We can read, eligible ಇರಲ್ಲ ಅವು.
Please,
ಟೈಪ್ಡ್ ಇರಲ್ಲ ಅಷ್ಟೇ. ಅದನ್ನೆಲ್ಲ ಮಾಡ್ಕೊತ ಕೂತ್ಕೊಂಡ್ರೆ ಕೇಸ ಪೋಸ್ಟ್ ಆಗಲ್ಲ. ಬರೇ ಲಾಯರ್ಸ್ ಇಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡೋದು ಬಿಟ್ಟು ಲೈಬ್ರರಿ ಟೈಮ್ ಸ್ಪೆಂಡ್ ಮಾಡೋದು ಬಿಟ್ಟು ಆಫೀಸ್ನಾಗ ಕೊಡ್ಬೇಕಾಗ್ತದೆ ಕಂಪ್ಲೈನ್ಸಿ.
please.
It may be posted in B group.
Post in B group in the second week of January 2020.
Great.
Ex parte interim order granted.
No,
The order of the KAT has had already implemented. The notice was served to the petitioner
No.
before the KAT. They have not filed any, they have not represented
no,
before
no,
the KAT.
not next.
Interim order
Interim
will
order
be
to
extended.
continue. First, we have noted the submission of answering respondent that the said order has already been given effect to. Okay. Next.
Number
The interim order may be extended, my lord.
Yes, extended.
Great.
Yes.
This is my lord.
Yes, Kashinath.
This my lord, the
Any
this
objection?
objection in respect of my lord protection of translated copies. Translated copies.
Second objection.
Second, my lord, it is typed, it is legible.
Correct. Council submits that the copy of annexure R1 is legible and we agree with that. So of his objection overruled. Now what is this matter, brother?
This my lord, here my lord, a departmental inquiry is initiated.
Huh?
Departmental inquiry is initiated.
Mike and expect.
Departmental inquiry is initiated, my lord, against petitioner. In respect of my lord, the caste certificate, which is the income and caste certificate secured by her husband from Bhadravati to produce it on behalf of her child to securing some scholarship before the government. In that, my lord.
One second. This is a little like Madhuri Patil.
No, it's a
Not like that.
Not.
Now what is the issue?
Issue is, my lord, the petitioner is working as my lord, is a police inspector. Her husband, my lord, is in, he's doing some private job. My lord, while he applied, my lord, then caste certificate and income certificate as a OBC. And my lord, he contended that my wife is a housewife.
Wife is a housewife.
Housewife.
Yes.
And he produced it, my lord, for securing some scholarship before the minority department.
When your wife is an inspector.
Police inspector. In that, my lord, she has nothing to do. She has not submitted any application. She is working at Davangere. He has secured it in the Bhadravati.
She does not know.
No. But at the time of submitting the application, the child was studying at Davangere.
Okay.
And my lord, the inquiry is.
How caste certificate, caste
income
is unknown to Islamic law. It's confined to
Yeah, my lord,
Hindu
it's under the
law and
OBC.
Hindu values, no?
Under the OBC, my lord, in the state, 2002 notification, the various, my lord, the religious and communities which have been
Are also enlisted.
yes, my lord. For the purpose of that, by virtue of the Indrasani case, my lord, some new group is constituted.
Show that to us.
Kind of,
Show that to us.
which my lord?
Our impression is because of bundle decision, we have learnt that caste is known to only Hindu law.
Yes, my
The
lord.
Hindus,
Yes,
not amongst other religions.
Yes,
If that is so, if your argument, you have to convince us. We have to learn it now from you, which is that, show it now.
that in the notification, 2000.
Yeah.
I had it, my lord, I'll pass it over.
Sorry,
230 minutes.
230. Urgency ಇದೆ no?
ಇಲ್ಲ, one day it may be.
Next week ಹಾಕೋಣ ನೋಡ್ಕೊಂಬರ್ಲಿ. How caste certificate, concept of caste certificate is alien to Islamic law, to our limited knowledge. Mullah,
Definitely.
Verma,
Definitely. my lord.
5G on
Yes.
outlines of.
Yes,
Caste certificate ಅಲ್ಲ, annual income certificate.
Income certificate.
Caste and income certificate.
ಅದ್ರಲ್ಲಿ ಏನ್
2A.
ಮಾಡಿದ್ದಾರೆ
You have to convince.
17,000
Caste and
rupees
income.
he has shown. And in fact, your lordship, that paid 1,000 rupees fees was paid. You, that
No, but what is fault with that lady? If husband who is residing.
lordship, she was aware of it. Being a sub-inspector, lordship may kindly appreciate. She
Assuming
cannot
that she
say-
is aware.
And she was aware of it, and that fees was also paid through her only.
To
Applicant,
ಮಗಳು
petitioner only.
ಫೀಸ್ ಕಟ್ಲಿಕ್ಕೆ ಕೇಳಿದ್ದಾರೆ.
And that has come in the evidence also, lordship, during the disciplinary proceedings.
No, next dating ನಮಗೆ confusion ನಮ್ಗೆ
I will produce that.
clarify that,
I'll
so that we'll use it in some other case.
Yes.
Call next week.
Any response?
Yes.
Number 5, government advocate.
English law, Kashinath. In English law, which Machinery of Justice by Jackson refers, wife till 1891 was considered part of husband, like our Ardhangini. And killing wife was not an offense till 1891. Just note down what I'm saying. It was considered as half manslaughter. And argument was, perhaps Bacon or somebody argued, that the half manslaughter is not defined as an offense, not designated as an offense. Therefore, you can't do anything. Then in 1891, law was changed.
In fact, my lords, there were some cases that said that wife incriminating the husband is not admissible because it goes against the right of self-incrimination.
Correct. Because wife was part of husband on that premise. Okay. Number 5, government advocate.
My lords, beg to appear for the petitioner state, my lords.
Aditya,
My lords,
please do not beg anywhere.
my lords,
It's your right to argue.
my lords.
Our duty to hear you. Where is the question of begging? We are not colonial regime.
My
Yes.
lords. My lords, there appears to be some minor office objection. I'm producing legible copies, my lord, of the pages that have been identified as illegible.
Office objections are complied with by producing the legible copies of the subject documents by a memo with leave. First.
My lords, matter pertains to a unique circumstance, my lord. State enters into an agreement to construct a highway from Bangarpet to the state Andhra border. The contractor does not perform the work. The inspection is carried out. The road is in shambles. The two options are given. Either you face action or we will close the agreement over here by settling. We will pay you some dues, about 11 odd crores, and we will foreclose this agreement, withdraw all claims, etc., so on and so forth. We will give it to some other contractor. He writes a letter. I will take your lordships through it. He writes a letter saying, yes, I prefer not to face legal action. I will foreclose and I will take the second option. Thereafter, he executes. This is on 20th of September 2021. In 2022, he executes a foreclosure agreement saying that he will not make any claims. Everything is settled. In fact, he executes it twice. First, he sends it by email. Then he comes to my office, executes it again. Thereafter, in order to collect payment, he signs another letter. I do not want, because initially, then after that, he went back on his word and he started making some claims. Then he comes to my office and executes another letter saying, I'm sorry, I will withdraw all claims. I do not want anything else except the settlement amount.
Where is that letter?
Everything is there, my lords. My lords, may kindly first take 233 is the joint inspection report, my lords.
No, that's all right. The letter, last letter, which you say.
It's at page 264, my lord. Annexure M.
Yes.
So in effect, my lords, this is the fourth document. First, his option of settling, then the two settlement undertakings, then this letter, my lords. Kindly see, my lord, I understand hereby express my willingness to settle the pending matter to the
last paragraph.
My lords.
I believe that a one-time settlement will be.
My lords, one-time settlement. Thereafter, my lords,
now what happened?
265, he gives an undertaking. This letter is not the only one. He gives an undertaking. Kindly see page 265 at 266.
He withdrew the CMP also.
He withdrew the CMP, my lords, but CMP, he plays a mischief on me. Here he says, I will withdraw the CMP because all claims are settled. When he withdraws the CMP at 267, he says because arbitral tribunal is already constituted by the Indian Roads Congress. And behind my back, he withdraws the CMP. I have thereafter obtained
IRC matter was pending when?
My lord, see, in the meantime, my lord, the arbitration clause, either on failure of the party to nominate or the presiding officer failure of the arbitrators to reach, IRC has, they have chosen IRC as the forum or the institution to nominate either upon failure or the third arbitrator. Therefore, my lord, tribunal enters reference. Before the tribunal, I file a section 16 application. Section 16 application, my lord, my contentions are twofold. One is that, look, he has executed 5 documents. So there is no question of coercion, etc., etc. He is a sophisticated party. He is a contractor. The second is that let us assume that he has some grievance against me. The foreclosure agreement does not contain an arbitration clause and therefore he has to go to a civil court. What the tribunal hears me, my lords, my submission is this. Let us say in my section 16 application, I had to lose for whatever reason. It could have been either on the strength of 5 documents, none of which are disputed, and I'll show your lordships that in the impugned order. The documents are admitted. Either on the strength of the document pursuant to 1991 of the Evidence Act, I had to succeed. Or the tribunal should have said, look, this is a triable issue. Therefore, we will frame a preliminary issue to decide this matter. Tribunal returns a conclusive finding. They should have said. My lords, the entire work is for 40 crores. He does 1/4 of the work.
Secondly, a new contract can come into existence by series of letters. Which is that judgment which says a novatio can arise by a series of subsequent letters.
My lords, in fact, my lords, here it is not just a series of letters, it is a contract itself, my lords. If your lordships take annexure E at page 238.
Anyway, issue emergent notice and interim order as prayed for.
Much obliged, deeply obliged.
There is one judgment of apex court, 2008 or 9, which Mr. Nariman had argued. Novatio can arise by series of letters between the parties post agreement. Take that. Yes.
Hearing on yes, number 6, Janardana Ji.
Yes.
Application has been filed, my lords.
Filed an
for
application.
amendment of complaint.
For
My
amendment
objections
of
also are
complaint.
ready.
Amendment of plain.
Amendment of plain, not in the appeal. But the facts are like this.
Praying for a day's accommodation, my lords. My objections are also ready. My lords, may kindly have this matter tomorrow, my lords. I'll ensure that my objections are filed in the course
After
of
1
the
year.
day. My lords, I
When the
collected,
application was filed.
I collected the application copy on last occasion from my learned friend.
That makes no sense. When it was filed,
On 22nd February 2023.
27 February 2023.
Please.
Under our rules,
Please,
2 weeks.
please.
So on that,
I
ground,
follow.
you say some other ground, we'll give time, not on that.
I follow. My lords. Once kindly accommodate by a day's, tomorrow itself I'll be ready with the.
Tomorrow we have difficulty, we'll have it because we are in the mid of hearing of another RFA. Not even the other one did. Application in IA number 1 of 2023, supported by an affidavit, seeks amendment of the plain. Only stamp duty, port fee, and these things, they should be heard before taking up the main, should put matter, reverse matter of the judgment, essentially. First up, the said application was filed on 27 February 2020. 21? 3.
21, February 23.
22nd, sir. 22nd February 2023.
22 February 23. First up, till date, no objections are filed. First up, hereafter, no objection can be filed either. First up, call this matter after 2 weeks at the request of counsel appearing for the rest.
Today, in the course of the day, my lords, may permit. In the course of the day itself, I'll ensure it.
No, that makes no sense. Otherwise, the court is not a shop.
I bow down to that.
That's next. We are allowing antalla. No objection.
I follow.
Other things you can argue.
Please.
Yes. Otherwise, they are only them. Yes.
Number 7, Varun Gowda. Inke Ramesh, HR Shourin.
Yes.
A special recruitment rule was made by the state government for the posts of principals in government colleges.
Yes, basically, but they're challenging the recruitment rules itself.
Well, they only
Additional documents is accept ಮಾಡಂತ. Additional documents ತೊಂಬೋಣ.
additional documents UGC regulation models for ready reference of the court. And the issue is this one. The
one date fix ಮಾಡ. We'll fix a date. Dispose of the matter.
very well.
Entry ಮಾಡಕ್ಕೆ ಕೊಡೋದು 16 ವರ್ಷ ಒಯ್ಯೋದು.
Short question is this, my lord. Whether entire cadre can be filled by direct recruitment without a chance of anybody being promoted. My lord, the chances of promotion are not conditions of service, but total absence of promotion opportunity that has been held to be contrary to Article 16.
ಎಷ್ಟನೇ promotion?
First promotion, what happens when a person joins as assistant professor? Earlier, my lord, they had a formula.
That judgment which said right to first promotion is a substantive right ಅಂತ hold ಮಾಡಿ Bihar.
That is, my lord, I have got 2 judgments, my lord. That is, one is Satyanarayana versus Purushottam.
Right.
Where para 30, Lordship, is SBC, no, for the
At
Supreme
least there
Court
should be
says that.
one promotion.
And the state's policy is, my lords, they have issued any number of OMs. There must be minimum of 3 promotions. Here, no doubt, I get financial upgradation to the scale of associate professor and to the scale of professor.
That was in lieu of promotion.
It is not leave of promotion. It is to remove stagnation. My lords, positive motivational encouragement is something.
In lieu of regular promotion.
What it says is, where a person is eligible, but there is no promotional opportunity, then you grant this Santa. But it cannot be substitute for promotion even without one. I join as associate assistant professor. Even if I am designated as professor and given the professor scale, as long as it is a time-bound promotion, I have to do the same work.
ಒಂದು ಪ್ರಮೋಷನ್ ಆಗೋದೇ ಇಲ್ಲ ಅಂತ.
ಒಂದು ಪ್ರಮೋಷನ್ ಆಗೋದಿಲ್ಲ ಅಂತ. The tribunal dismisses my application without notice to the respondent. ಇಷ್ಟೇ ಕೇಸ್ ನಂದು, ಬೇರೆ ಏನಿಲ್ಲ.
Government has to say.
Yes, what is that's the only case. That's the shortest argument in his career, perhaps. Yes, what do you say?
I understood the issue, my lord. Their grievance is that only through promotion, direct recruitment, they are entitled for principal post, my lord.
No, how can you foreclose?
The special rules, my lord.
Very well. We call it as special by English word, special attack, but special agala. How can you foreclose?
Yes.
All these people, very, see what he says here, what you are giving in the alternate, it cannot be by way of substitution. It is only ಮಕ್ಕಳಿಗೆ ಒಂದು ಪೆಪರ್ಮೆಂಟ್ ಕೊಟ್ಟು ಏನೋ ಒಂದು ಸಮಾಧಾನ ಮಾಡ್ತೇವೆ.
ಅಳಬೇಡ 12 ಗಂಟೆಗೆ ಊಟ ಕೊಡ್ತೀನಿ.
ಬಟ್ ಒಂದು ಪ್ರಮೋಷನ್ has to be granted ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
That is not in KGS, but CSIR, a person is recruited not for a job, but for a career ಅಂತ.
It's not just contract. We move from contract to status. Tulsi Ram Patel. Yes, Tulsi Ram Patel versus.
And earlier to that.
Earlier, okay. Anyway, so what is that's the only point what you say?
I'll come prepared.
Again, time. All right, call this matter in the second week of January. Since short matter lies in a narrow compass. Okay. Application for production of additional documents
and raising
is
additional
allowed. Is allowed. Okay. Next. Second week of January. Next.
Meanwhile, they are likely to this one because what has happened, written examination is over.
If any action prejudicial to the interest of the petitioners is taken, the same shall be lis pendens. Okay. Great.
Number 8, government advocate.
My lord, appearing for the respondent in this matter. Lord, the petition does not survive, my lord, because the respondent prayer has been already implemented by the government as well as the state, my lord. So therefore, the petition does.
You are a respondent or
I'm respondent in this matter.
you are respondent. What
Yes,
do you say?
State appeal. I have to take instructions.
Call week after next at the request of GA. First. Have you seen that? It has become infectious.
Yes, my lord, because tribunal order itself is implemented and accordingly the seniority has been given to the respondent.
Next
So
week
therefore,
it
the
will
writ petition does not.
Implement but right of challenge hogalla. Suppose if the decretal money is paid, right of
Alla,
filing appeal.
Recently, after filing the writ petition
Waiver
itself,
of-
it is implemented.
All right, let us see.
Please.
Next.
Number 9, government advocate.
Application filed for impleading, lords.
Impleading application. What is the issue just now?
Regarding UGC, your lordship, you have to pay that incentive by the UGC. In this case, your lordship, at the instance of
Yarn
the
implement.
direction of the UGC.
Not the government wants to implead UGC. According to me, my lord, UGC may not be a necessary party.
How can you change?
Because
the
they
cost
have to
title?
pay it, your lords.
That's all.
No,
Cost title is a matter of.
The court has
communist-
directed me, lords.
No.
Court
You
has
can
directed.
say, who directed you?
Please, please,
To implead.
please, lord.
Where is that?
Last date of hearing. Order.
This court has, the coordinate bench has said that.
Very well.
A coordinate bench of this court wide order dated 12/9/2024 had said as first off, in terms of the above order, the present application supported by the affidavit has been filed seeking implement of UGC as respondent, as a respondent. Please go. First, the orders made in the successive stages of the proceedings also suffer res judicata. First, in view of the above, the subject application having been favored, implement as sought for is permitted. Yes, petitioner to amend the cause title forthwith. ಮಾಡಿಕೊಟ್ಬಿಟ್ಟು.
ಅಲ್ಲ ಅವರೇ ಮಾಡ್ಬೇಕು.
ಅವ್ರು ಹೆಂಗ್ ಮಾಡ್ತಾರೆ? Petitioner.
ನಾನು ಇರೋದು.
Petitioner.
Lord, it lies in a very short compass.
ಏನು?
4 increments were directed to be extended to the respondent in terms of the UGC regulations. My lord, at the time of initial entry into service.
ನೋಡೋಣ ಈಗ UGC ಆಯ್ತಲ್ಲ, ಯಾರು UGCಗೆ? Panel counsel. HR Shourie. Panel counsel is requested to accept notice for newly added respondent, UGC. First off, petitioner to serve a copy of the petition along with all documents on the said panel counsel immediately. Okay. Call after 2 weeks.
Grateful.
Okay.
One indulgence, my lord.
Ah.
Previous matter, interim order was there.
ಅಲ್ಲಿ ನೋಡಿ, previous matter ನಲ್ಲಿ entry order to continue.
Obliged.
Okay. ಇದೆಯಾ? Until further orders ಇದೆ.
Yes.
Okay.
Important.
Yes, Mr.
May I
Chaitra
seek
J.
a
Narayan.
passover, my lord?
Passover.
Ali,
operational creditor is yet to be served, but we have no objection for the intervening applications to be allowed. The lordship ordered notice to the operational creditor. They're the contest.
IA 2 of 2024 allow ಮಾಡೋಣ?
Yes.
Intervener application.
Yes, my lord. I filed the intervener application.
ಅದನ್ನ allow ಮಾಡೋಣ. Application in IA number 2 of 2024 supported by an affidavit is by the intervening party. And the said application unopposedly having been favored, intervention as sought for is permitted.
Respondent 3
Petitioner to amend the cause title.
intervening.
Showing the applicant as intervener.
ಹೌದು, intervening ಏನ್ ಬೇಕಾಗಲ್ಲ ಅಂತ.
ಮತ್ತೆ
ಮಾಡ್ತೀನಿ.
ಬೇಕಾಗುತ್ತೆ. Amend the cause title suitable.
But respondent 3 is the contesting respondent. Notice is yet to be served.
ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲನೋ?
ಇಲ್ಲ ಆಗಿಲ್ಲ. Learned advocate from Chennai was
My lord, there
represented.
was a stay on the last occasion which was granted. May I seek a passover led by Dhyan Chinappa and Mr.
It's all right, but ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಆಗ್ಬೇಕು. ನೋಟಿಸ್ ಸರ್ವ್ ನೋಟಿಸ್ ಕಳಿಸಿ ಆಗಿದೆಯಾ?
Yes, even IRP has to be served.
Await.
I appear for the RP.
IRP.
Shri so and so appears for IRP.
One submission.
ಯಾವ respondent?
Respondent.
Respondent 3.
Respondent number 3 IRP.
I appear for.
IRP respondent 4. I'm sorry.
For
IRP respondent 4.
For first off, service of notice on respondent number 3 is awaited. Interim order to continue. Call this matter immediately after service.
One
My lord.
submission with regard to arraying a register of NCLT, NCLAT as parties, my lords. That may be avoided because.
No.
My lord, on the
Yes.
last occasion, it was purposely posted on this date for us, for them to show locus and for us.
Yes, we are ready.
Respect to the
There are 2
interim
Supreme
order.
Court
My lord,
judgments.
may I seek a small passover, my lord?
No, not today. Not today. Service
Contesting
ಆಗ್ಬೇಕು.
respondent.
When we issue notice, service has to take place. Otherwise, we can't hear that way.
But as a matter of fact, there are 2 Supreme Court judgments and we are ready. But the contesting respondent.
Post immediately after service. ಯಾವುದು?
My lord, at least a
Interim
date
order
may
ಇತ್ತಲ್ಲ,
be
ಯಾವ್ದು
fixed.
ನಾ-
my-
you remember? There was an interim order.
Got a copy?
Interim order ಇಲ್ವಾ?
Yes, there is an interim order. No precipitative action. person.
ಯಾಕೆ ಇದ್ರಲ್ಲಿ ಯಾಕಿಲ್ಲ ಅದು? I remember I recast that order after going back to, we went back to chamber and recast that, na? Connect ಅದ್ರಲ್ಲಿ ಅಷ್ಟು ಕಂಟಿನ್ಯೂ. Interim order to continue. ಒಂದ್ರಲ್ಲಿದ್ರು ಸರ್, ಅದು ಯಾವ್ದ್ರಲ್ಲಿದೆ ಅದು ಕಂಟಿನ್ಯೂ.
Blood in the, there is one more petition filed by Mantri. There
All
also,
along petition.
ಅದ್ರಲ್ಲೂ intervening ಮಾಡ್ಬಿಡ್ತೀನಿ ನಾವು.
ಯಾವ್ದ್ರಲ್ಲಿ? ಅದು ಇದು ಆಗಿಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಅವ್ರ application ಹಾಕಿಲ್ಲ, but.
No, we filed it. We filed it.
Yes, we will amend all the 3 cast titles.
ಅದರಲ್ಲಿ. All the 3
Yes,
matters
yes,
interim.
yes.
Okay. Post immediately after service. Okay. Service is complete. Okay.
by 11. Parmeshwarappa.
My lordship, this petitioner preferred this petition challenging the dismissal order of
Entry ಮಾಡಿದ್ದೇನು?
no, my lord.
Entry ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ sir.
After detail
ಇದರಲ್ಲಿ
inquiry, after detail inquiry, the concerned
The
deputy commissioner is give a report, my lordship, only 4 acre 29 kuntas is land grab. That is, my lordship, that the already order for judicial Tahsildar to recover that land.
My lordship,
Yes.
In kindly
the
see,
respondents number 1 to 3 conducted PODI on the basis of the grant order, my lordship. That grant order not belong to Basopura village, my lordship.
What the tribunal, the special court has said now?
annexure A, my lord.
A.
Without conducting any inquiry, without conducting spot inspection, without giving opportunity, dismissed this complaint, my lordship. The grant order belongs to one Tipsandra village, Kerpuram Obli. However, colluding with the my lord.
You are complainant.
Complainant, my lord.
Not this.
Fine. In the relevant pages, my lordship. Para 12 of page 16.
ಇದ್ರ ಮೇಲೆ appeal ಇಲ್ಲ no? Orders of the
Land
special
grab.
court ಮೇಲೆ ಏನೋ ಕೊಡಿ ಯಾಕೆ ಕೊಡಿ? What is that land grabbing, prevention of land grab?
Land grabbing.
Order final ಅನ್ನೋದು?
This is final, my lord. Because here only appeal is High Court.
ಮತ್ತೆ appeal ಅಲ್ಲಲ್ಲ ಇದು?
Writ petition.
ಮತ್ತೆ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು. ಎಲ್ಲ ನಾವೇ ಎಲ್ಲ ಹೇಳ್ಕೊಟ್ಟು ಫೈನಲ್.
ಅದಕ್ಕೆ MFA ಅಂತ.
MFA ಅಂತಂದ್ರೆ ಯಾರು ಅರವಿಂದ್ ಕುಮಾರ್ ಸಾಹೇಬ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವುದೋ ಒಂದು ರೆಗ್ಯುಲರ್ ಅಪೀಲ್ ಹಾಕೋಬೇಕು, ಮಿಸ್ಲೇನಿಯಸ್ ಅಪೀಲ್ ಹಾಕೋಬೇಕು ಅಂತ ಏನೋ ಹೋಲ್ಡ್ ಮಾಡ್ದಂಗಿದೆ ಕೊಡಿ. ಇದೇನು ಆಕ್ಟ್ ಈಗ ಬೇಡ ಆರ್ಗ್ಯುಮೆಂಟಿಗೆ ಏನಪ್ಪ ಐ ಡು ನಾಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಆಕ್ಟ್ ಅಂತಾರಲ್ಲ, ಇದಿಲ್ಲ, ಹಾಗೆ ಏನೋ ಒಂದು ನೋಡಿ ಎಂತದ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಎಂತದ ಒಂದು ಮಾಡಿ ಹೋಗಿಬಿಡೋದು ಹಲ್ಸ್. ನಿಮ್ಮ ಮತಿಗೆ ಎಲ್ಲಿದೆ ಆಕ್ಟ್? You want to argue, you want to defend the government, the authority without statute? We'll write about you to remove you from the panel.
It is in chamber, my lord.
How are you going to see the pages in the chamber? What is that you are answering?
Kindly pass over, my lord.
Why are you not bringing the book? What kind of government advocates we are having in our court? Not all, he comes with lot of preparation. ಒಂದು ಇಲ್ಲ ತೊಂಬರ್ತೀವಿ ಅಂತ ಅದು ಇಲ್ಲ. I will write that too, you should be removed ಅಂತ ಬರಿತೀವಿ.
No, kindly pass over, I will bring.
Why have you not brought?
Sorry, my lord.
We'll write to the government, remove advocates who do not perform well. Always the government is destitute. Nobody represents properly, barring 1 or 2 people.
Kindly, my lordship, portion of the order. Kindly see the order portion, my lord.
We will not see. You are not answering the question of law by turning the pages of the book. We are not here to please you. We don't please anybody. Yes. Call week after next. Both the sides have to address the question as to whether the order of the special court is appealable or not by turning the pages of act. Yes. Yes, next.
Chamber 12 and 13 urgent, chamber 14.
ನಾವೇ ಮಾಡಿದ್ರೆ ಅವರೆಲ್ಲ ಯಾಕೆ? ನಮ್ಮಷ್ಟಕ್ಕೆ ನಾವೇ ಮಾಡ್ತೇವೆ ಎಲ್ಲ.
Receive instructions to withdraw the
ಜಡ್ಜಸ್ ಬಿಗಿ ಇಲ್ಲದೆ ಇಷ್ಟೆಲ್ಲ ಆಗ್ತಾ ಇದೆ. ಏನ್ ಬೇಕಾದ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೋದು, ಏನ್ ಬೇಕಾದ್ ಹೇಳ್ಬೋದು, ಹೋಗ್ಬೋದು. ಅವ್ರನ್ನ ನಾವು ವಿ ಶುಡ್ ಕನ್ಫ್ರಂಟ್. ಅವಾಗ ಒಂದು ಲೆವೆಲ್ನಾಗ ಇರ್ತಾರ. ಅದರ್ವೈಸ್ ಪ್ಯಾನಲ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಏನೋ ಏನಾಗ್ತದೆ ಅನ್ಕೊಂಡು ಎಲ್ಲ.
Receive instructions to withdraw the writ petition, my lords. I've received instructions to withdraw it. So placing a memo on record.
Serial number
14, my lords.
14. Counsel for the petitioner has filed a memo seeking leave of the court to withdraw the petition. First off, the memo dated 5/11/2024 reads as under. Objection idea? Yaru respondents?
State, my lords.
The net counsel appearing for the contesting respondent signifies no objection universally for grant of leave to withdraw. Full stop. In view of the above, writ petition is disposed of as having been withdrawn, with no leave to relitigate whatsoever. Next.
Three group matters, number 15. Gururaj Kulkarni. Supa, yes.
Yes.
The matter of time-bound promotion, my lord.
Time-bound promotion.
Promotion.
ಎಲ್ಲಿದ್ದಾರೆ
Yes.
ನಿಮ್
Here it-
Then what is the issue?
So as per notification dated 17/5/2000, it is clarified that time-bound one promotion are based on length of service.
Read para 3. Come to page 32. ಏನ್ ತಪ್ಪಿದೆ ಇದ್ರಲ್ಲಿ?
Yes, my lord. Dismissed on the ground that the letters dated 96 and 97, 98 they are seeking relief on the OA would be applicable in case of seniors where junior was brought to unit rule 38 of PNT.
But you were not senior.
Well, that notification says it depends upon length of service. Meanwhile, he retired, he has taken voluntary retirement. They have given a reply as per annexure 8 that he is not entitled.
Correct. ಅದು ಏನ್ ತಪ್ಪಿದೆ ಅಂತ? You were not senior at all.
Yes.
If you were to be senior,
Yes,
then
yes.
perhaps because junior is given, you have to be, no? That's the principle in service law, which Ramajoy's services under the state treats.
With that observation, it may be dismissed.
Observation. Petitioner, he retired, no?
Retirement. He has taken voluntary retirement on
A
9/1/2006.
civil servant who has taken voluntary retirement
On 9/1/2006.
on
9/1/2006.
9/1/2006 is knocking at the doors of writ court or assailing the Central Administrative Tribunal's order dated 30 January 2020, whereby the relief of promotion which he had sought for in the said OA has been denied. Full stop. Learned counsel for the next paragraph. Learned counsel for the petitioner vehemently argues that in the fact matrix of the case, the relief of promotion which client had sought for ought to have been granted in view of the letters dated 8/2/1996, 5/8/1997 and 1/1/1998, on which the said claim has been structured. First stop. Next paragraph. Learned counsel appearing for the official respondents opposes the petition, drawing our attention to the contents of para 3 in the order of pronouncement. First off, the same reads as under. Nodama, page 32. Page 32 ದಲ್ಲಿ mark ಮಾಡಿದ್ರು. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we are in agreement with the observations made at para 3 of the subject order. Full stop. In view of the above, petition is devoid of merits and accordingly it is dismissed. Courts having been made easy. He was not senior at all.
Yes, my lord.
That's why.
And my lord, there is a delay of 17 years, my lord. Much obliged.
ಅಲ್ಲಿ ಒಂದು
My
sentence
absence may.
ಅಲ್ಲಿ ನೋಡಮ್ಮ, ಈ ಕಡೆ ಲಕ್ಷ್ಯ ಇರಬೇಕು ಕೆಲಸ ಮಾಡುವಾಗ. The panel, the CGC
Yes, my lord.
representing the answering respondents points out, makes submission in justification of the impugned order and the reasons on which it has been constructed. Full stop. She also points out that the administrative tribunal exercising power under section 19 of the Administrative Tribunals Act 1985 shares the writ jurisdiction of this court in the light of Apex Court decision in L. Chandrakumar versus Union of India, AR 1997 SC, so and so, so and so. And therefore, delay and latches, as would apply to writ courts, would also apply to the tribunal. First, so contending, he seeks dismissal of the writ petition. First, account of having heard, so and so, so and so.
One submission. Madam.
Yes.
As per Annexure A12,
Yes.
that notification says, as per said postal direct letters only, UDC working in the SBCO or on or before 1897 are eligible.
Correct.
Delay not applicable
Why?
in this case.
Why?
It is applicable from the year 91 itself.
That notification is issued when? Therefore, delay applies. Delay and latches apply.
That is 18, madam.
Huh?
18.
2000?
26/9/18.
26/9,
Yes.
2018.
And page 75, madam.
Padi. Petition.
Annexure A12, page 75. Second para.
All right. Even then, a delay. Section 21 prescribes 1 year.
Yes, one.
Last last having heard ಆದ್ಮೇಲೆ ಅದಾಯ್ತಲ್ಲ ಅದಾದ್ಮೇಲೆ ಇನ್ನೊಂದು ಗ್ರೌಂಡ್ ಹೇಳ್ತಾ ಇದ್ದೇನೆ. There is force in the submission of learned CGC representing the respondents that the claim is barred by delay and latches because of the text of section 21 of the 1985 Act, which reads as under. First, next para, in view of the above. Next para.
Much obliged.
In number 16, Prithvi Shemke.
For the petitioner.
Yes, petition.
I have challenged the order of the tribunal, remanding the matter, my lords, to the government. My lords, on the last occasion, I must bring to your lordship's notice, I was directed to implead Lokayukta, my lords. I have impleaded and served. I have filed the acknowledgement also, but the name of the Lokayukta council is not shown.
PC Act.
PC Act, my lords. My lords, acquittal in criminal
Registry
case.
to.
My lords,
No, Rudrappana.
PV Rudra.
PV Rudrappa.
Yes, my lords. After 20
Registry.
years, it is remanded. Notice is issued, my lords.
ಅಲ್ಲ, ಅವ್ರು
ಲೋಕಾಯುಕ್ತ
appear ಆಗ್ಬೇಕಲ್ಲ.
ಆಗಿದ್ದಾರೆ ಅವ್ರು ಅಶ್ವಿನ್ ಹಾಲಡಿಗೆ ಸರ್ವ್ ಮಾಡಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಹಾಕಿದ್ದೇನೆ
ಅವ್ರ
ಬಟ್
ಹೆಸರು
ಅವ್ರ
ತೋರ್ಸಿಲ್ಲ.
ಹೆಸರು ತೋರಿಸಿಲ್ಲ.
Registry to show name of panel counsel, Mr. Ashwin Haladi, as appearing for respondent Lokayukta.
3 ಲೋಕಾಯ
Point number 3 Lokayukta. First, call after 2 weeks.
ಪ್ಲೀಸ್.
Number 17, K. Prasanna Shetty.
Yes, Prasanna.
Satish
Kind of
K.
next week, my lord.
Call in the second week of January on request of counsel for petition. Huh? January. Yes.
KN Puttagowda name may kindly be deleted. No?
Irli, ಅವ್ರದ್ದು ಹೆಸರು ಇರ್ಲಿ.
Please, I'm sorry.
A great lawyer.
I'm sorry.
Very great lawyer he was. He is. Now health is upset. It will happen to everybody.
Always, my lord.
After all,
Please.
let the name be there.
He was our
Want to
president.
see that name.
He was our
We
president of-
derive some inspiration from his conduct, from his virtues. Yes.
In number 18, Sumona Naganand.
Lord, I appear for the
P.B.
petition. in this
Shivkumar.
case, my lord.
Yes.
My lord, this petition, my lord, has become infructuous. Lord, I had challenged the
ಒಂದು ಮೆಮೊ
order.
ಕೊಡಿ.
Memo, my lord, sign ಆಗಿ ಬರ್ತಾ ಇದೆ, my lord. Kindly pass over.
ಬರ್ಕೊಳ್ಳಿ. Learned counsel appearing for the
Lord, I have a
petitioner.
submission, my lord. I seek liberty, my lord. That is why I'll make the submission.
Liberty
In this petition, my lord, I have challenged an RP order passed in a review petition. My lord, in the review petition, the tribunal was pleased to revive the original complaint. And subsequently, my lord, now the original complaint and order of cognizance is passed. Now, my lord, the only liberty that I'm seeking is I'll withdraw this petition and I may be permitted to file a fresh petition challenging the cognizance order, my lord.
That order. Learned counsel for the petitioner submits, and we agree that this petition, having become infructuous, should be disposed of accordingly, reserving liberty to litigate afresh on the basis of fresh cause of action, cognizance of the offences having been taken. Okay. ordered accordingly and WP is disposed of. Yes.
Number 19, Ranganath S. Dois.
ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಈಸಿ ಅಂತ ಮಾಡ್ಬೇಕು, ಎಲ್ಲೆಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿದೆ ಕಾಸ್ಟ್ ಮೇಡ್ ಈಸಿ CME. ಓಕೆ.
Number 19, Ranganath S. Dois.
Call after 2 weeks to enable counsel for the petitioner to come and argue. Next.
Scene number 20, NK Ramesh.
But the similar issue, my lord, is pending before the division bench with regard to, my lord, the question is this, my lord. Once, my lord, the expert committee has opined and on the basis of which, my lord, a provisional select list is announced. Thereafter, certain, my lord, objections were invited. Objections for provisional select list was called, not for the questions.
Key answer.
Yeah, key answers. Provisional key answers. Not for the key answers, it's only for the provisional select list.
Provisional select list founded on key answers.
On key. That, my lord, the tribunal taken upon itself, my lord, then.
Did I hear this matter before the division along with justice?
I think so, my lord. That matter is still pending, KPTCL matter, your lordship.
Correct.
That, my lord, we are awaiting, that is listed, my lord, for hearing. My lord, on,
All right. Call this matter immediately after the disposal of writ appeal number.
writ appeal number 1204 of 23.
1204 of 2023.
20.
Pending on the file of coordinate bench. First, concerned parties to move a memo after its disposal.
Yes.
Okay. Will do.
For 21, 22 urgent. Number 23, Maruti GB.
My lords, I appear for respondent number 3 and 4, my lords. Small inconvenience, my lords. Matter may be taken up tomorrow or Friday, my lords.
Urgency ಏನ್ರ ಇದೆಯಾ ಶಾಸ್ತ್ರಿಗಳೇ?
Interim order is there, man.
Interim order is there na? Interim order to continue ಅಷ್ಟೇ. Call this matter in the second week of February, first week of February 2025. Interim order to continue.
My lords.
Okay.
Tomorrow or Friday, my lord.
ನೀವು ಹೇಳ್ದಂಗೆ ಇರಲ್ಲ ನಮ್ಮ ಕ್ಯಾಲೆಂಡರ್, ಏನೇನೋ ಇರ್ತದೆ. ಈ ಮ್ಯಾಟ್ರ್ ಬಂದಾಗ ರೆಡಿ ಇಲ್ಲ ನಾವೇನ್ ಮಾಡೋಣ? ನೆಕ್ಸ್ಟ್ ನಾವ್ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡೋದೇನು, ಮ್ಯಾಟ್ರ್ ಬಂದಾಗ ಆರ್ಗ್ಯೂ ಮಾಡ್ರಿ, ನಿಮ್ ಪುಸ್ತಕಗಳನ್ನ ತೊಗೊಂಬರ್ರಿ, ರೂಲಿಂಗ್ಸ್ ತೊಗೊಂಬನ್ನಿ, ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಮಾಡಿ, ಒಂದು ಅಪ್ರಿಶಿಯೇಷನ್ ಬರೀತೀವಿ ನಾವು.
Senior is in Dharwad.
ಸೋ ವೆಲ್ ಅಂತ ಬರೀತೀವಿ.
Senior Dharwad.
ನಾವ್ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ, ಅವ್ರು ಧಾರವಾಡದಿಂದ ಬರುವಾಗ ನಾವು ನೆಕ್ಸ್ಟ್.
Number 24, Vijay Kumar.
ಕೆಲಸದಲ್ಲಿ ನಾವೇ ಯಾರಿಗೂ ಮರ್ಸಿ ತೋರ್ಸಲ್ಲ, ನಮಗೂ ಮರ್ಸಿ ತೋರ್ಸೋಣಲ್ಲ. ಎಸ್, ಕರೆಕ್ಟ್ ಕೆಲಸ ಆಗ್ಬೇಕು. ಜನರೆಲ್ಲ ಕಾಯ್ತಿರ್ತಾರೆ ಪಾಪ.
The penalty of withholding 2 increments was under challenge before the tribunal, my lord. The matter was referred, my lord, I was constrained to approach the tribunal on more than 3 occasions.
Ready in the matter?
I will have not.
Well, ಕೊಡಿ ಒಂದು ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
Please.
Week after next. The request of learned AGA.
Furnished, I have already furnished, well, I will furnish one. Please.
ಇನ್ನೊಂದು ಕೊಡ್ಬೇಕು.
Earlier proceedings.
ಕಳೆದಿರ್ತದೆ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಅವರು, ಪ್ಯಾನಲ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಅವ್ರಿಗೆಲ್ಲ ಕೊಡ್ಬೇಕು. ಅಲ್ಲಿ ಕೃಪಣತೆ ತೋರ್ಬಾರ್ದು, ನಾವು ಕೃಪಣತೆ ತೋರಕ್ಕಾಗ್ತದೆ ಅಷ್ಟೇ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ.
Please.
Number 26, Raghavendra G. Gayatri.
For the petition.
Yes.
Petitioner is an aspirant in my lord's motor vehicle.
He is held up in another court in arguments. Kindly pass for me.
He is held up in another court.
Case,
APSC.
case of re-medical examination is on the ground of parity of other coordinate benches decision is what I am asking for.
In your favor.
Yes, my lords.
ಅವ್ರೇನೋ ಬೇಕು ಅಂತಾರ. ಇವತ್ತ ಆಗಲ್ಲ, ಬೇರೆ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಪಾರ್ಟೆಡ್ ಹಿಯರಿಂಗ್ ಏನೇನೋ ಇಟ್ಕೊಂಡಿದ್ದೀವಿ. ವಿಲ್ ಹ್ಯಾವ್ ದಿಸ್ ಮ್ಯಾಟರ್ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್. Okay. Next, week after next, at the request of counsel for respondents.
Please.
Yes.
Number 27, MC Nagasri. We are Sarthi, number 27.
Regarding medical officers transfers, counseling, your lords.
Medical officers counseling. Counseling ಇದೆ ನಡೆದದ ಈಗ.
ಆಗ್ತಾ ಇದೆ, ಅದು ಮುಗ್ದೋಗಿದೆ ಸ್ವಾಮಿ, ಇನ್ಫೆಕ್ಷನ್ಸ್ ಆಗಿರ್ಬೇಕು.
ಅವ್ರು ಅಟ್ಲೀಸ್ಟ್ ಕೇಳ್ಕೊಂಡು ಹೇಳಿ, ಅಲ್ಲಿ ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ. ನಾಗೇಶ್ ಇವ್ರಿಗೆ ಒಂದು ಫೋನ್ ಮಾಡಿ
ಅಲ್ಲ NOC ಅಂತ ಇದೆ.
NOC
ಇನ್ನೊಂದು ಮೇಲೆ ಬಂದಿದ್ದಾರೆ ಸರ್ ಅವರು.
ನೀವು ತಿಳ್ಕೊಂಡು ಹೇಳಿ ಏನಾಗಿದೆ ಅಂತ.
Please.
ಪಾಸ್ ಓವರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ.
Please.
All next week to enable counsel for the petitioner to come and argue.
Number 28, Ranganath S. Joyce.
ನೋಡಮ್ಮ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿದ್ವಲ್ಲ ಅಂತದ್ದು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು. ರಂಗನಾಥ್ ಜೋಯ್ಸ್ ಮೇಲೆ ಇನ್ನೊಂದಿದೆ ಅಲ್ಲ ಅಂತದೇ ಆರ್ಡರ್. ಎಸ್.
Number 29, Vijay Kumar.
ಎಸ್.
Number 3, my lords. Copies to be served, my lord. Copies not served.
ಕಾಪಿ ನಾಟ್ ಸರ್ವ್. ಕಾಪಿ ಕೊಡಿ. ಸಾಮಾನ್ಯ ಸರ್ವ್ ಮಾಡಿರ್ತಾರ ಅವರು. ಅಲ್ಲ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ ವಿಜಯ್? ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
Next week.
ಅದೇ ನೆಕ್ಸ್ಟ್ ವೀಕ್ at the request of respondent. Yes.
Number 30, Satish K.
Yes, Satisha.
Last occasion, what the
ಏನಿದೆ?
direction was issued to my learned friend to verify whether option was called, my matter pertaining to my lord, the reservation under 371J. When I was on maternity leave, my lord, the option was called for. My lord, the cap was 45 days. I have not exercised my option within 45 days because I was in maternity leave ಅಲ್ಲಿ ಇದೆ.
Verify, Lord. I will seek instructions. Lord.
All
I'll
right,
make
2 weeks
submission.
at the request of. Next. ಅಷ್ಟೇ ಪಾಯಿಂಟ್ ಅದು. ವೆರಿ ನ್ಯಾರೋ ಕಂಪಾಸ್.
Very.
ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು.
I will submit.
He was on maternity leave. ಅವಾಗ ನಂಗೆ ಕಮ್ಯುನಿಕೇಶನ್ ಆಗಿರಲಿಲ್ಲ, ಆಪ್ಷನ್ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡಿಲ್ಲ. ಅಂತದ ಕೇಸ್ನಲ್ಲಿ ಏನ್ ಅಂತದ ಕೇಸ್ನಲ್ಲಿ ಮಗನೆಸ್ಟ್ ಹೋಲ್ಡ್ ಮಾಡ್ಯಾರ. ಎಸ್.
Number 31, A.V. Gangadharappa.
Appear for the applicant.
Government advocate.
Yes.
There was a direction by the bench
Lord, there was instruction, my lord.
appearing.
Instructions whether there is any pending inquiry against the petitioner, my lord. I have communicated DMA, my lord, Director of Municipal Administration.
ಯಾವತ್ತು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿ?
ಮಾಡಿದ್ದೀವಿ. ನೆನ್ನೆನೆ ಮಾಡಿದ್ದೆ.
ನಿನ್ನೆ?
Yes, my lord. Because now, my lord, they say that the file has, they have sent it to the government. If my lords may kindly pass over, I'll take instructions, my lord.
ತರ್ಸಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ತೀವಿ.
Please, my lord, please.
Petitioner has retired from service on 29/2/2012. More than 13 years have elapsed.
I beg your
Even
pardon.
till this day, my terminal benefits, pensionary
given.
benefits and other benefits have not been paid. Even DCRG has not been paid. He has undergone, his wife has undergone
2000 February
bypass
2012
surgery.
ರಿಟೈರ್ಮೆಂಟ್.
Yes, my lord.
ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? ಪಾಸ್ ಓವರ್ ಹೇಳ್ಬೇಕು.
I'll
You can't
get-
keep
get-
a person who has served like that. You are not East India Company. You are a welfare state. Yes.
Yes, East
Pass
India.
over, pass over.
East India
Ah.
Company.
Because the date given matter, my lord, we'll come to know only late evening, these matters. So immediately I've tried to communicate and secure the instructions, my lord.
We will call this next week.
Yes, my lord.
Got it. Finally,
This order was passed on 13th of September 2020.
I will get, my lord.
the the order dated 13/9/2024 reads as first, the government advocate seeks a short accommodation for furnishing the necessary information contemplated in the said order. First, all this matter, date kodi. Next week on date kodi. 19th of November. Finally.
Please, my lord.
Okay.
Number 32, Ajit PB.
Yes.
The petitioner has been placed under suspension on the ground that he was relieved from his office at Mysore pursuant to a transfer on 9th of February, but he has put up a file on 10th of February recommending certain things to the deputy commissioner. That is the only allegation. Then, my lords, I pointed out that the date mentioned in the charge taking report is wrong. It is not 9th because 9th, it was a Friday prior to second Saturday. I received the transfer order only at 7:47 PM. That too by WhatsApp. And there was no possibility of my handing over charge on 9th. Charge was actually handed over on 12th, that is a Monday. And it was an election transfer.
Saturday and Sunday intervening.
And then, my lords, I also placed on record.
Charge was handed over on same day.
Same day.
So 9 to 2020.
Charge, my lords, charge CTC mentions the date as 7th.
Yes.
But my submission is that is an error because the files have been handed over to my successor only on 12th February at 12:47 PM, as could be seen by the e-file forwarding register. That e-file forwarding register also I have placed on record at page 137. It is not this single file, and all the files, my lords, whichever were there to be transferred to my successor, they have all been transferred only on 12th February 2024 at 12:47. Then, my lords, after hearing both the sides, this honorable court, my lords, on the last occasion, on 27th September 2024.
Order sheet. You forwarded the file after handing over is their version.
No, my lords, what they say is, on 10th, I have attended office.
Where is the charge?
Charge, my lord, the suspension order is at page 100, my lords.
Lordship, in the meanwhile, there was a request from him, Lordship. There was a direction also to consider his request. And the endorsement issued, Your Lordship, to that effect that his suspension cannot be removed, withdrawn. That endorsement is
Pursuant
already
to the
there.
order
He has
passed by
this honorable court, Your Lordship.
What this?
ಅದೊಂದು ಮೆಮೊ ಎಲ್ಲ
ಹಾಕಿ ಕೊಡ್ತೇನೆ ಸರ್. ಅಲ್ಲ ಇದು ಸ್ವಾಮಿ ರೆಫರೆನ್ಸಿಗೆ ಮಾತ್ರ ಕೊಡ್ತೇನೆ.
ನೋ ಸ್ಪೆಷಲ್ ಸ್ಟೇಟಸ್ ಫಾರ್ ದಿ ಗವರ್ನಮೆಂಟ್.
ಇಲ್ಲ 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 ಹಾಕಿ ಕ್ಲೀನ್ ಕೊಡ್ತೇನೆ ಸರ್. Just only for reference. Just now I have received it, Your Lordship. I will sub.
Password. Shall we call it next week?
Please.
ಅಲ್ಲ ಇಷ್ಟಿಷ್ಟಕ್ಕೆಲ್ಲ
ಅಲ್ಲ ಇಷ್ಟಕ್ಕೆ ಬೇಕಾಗಿಲ್ಲ ಅದಕ್ಕೆ ಅಲ್ಲ ಇದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇದೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕಾಗ್ತದೆ.
Not that. Not
What they
we are
say
saying
is
something
not-
else. ನೀವು ಇಷ್ಟಿಷ್ಟಕ್ಕೆಲ್ಲ ಅವ್ರನ್ನ ಸಸ್ಪೆಂಡ್ ಮಾಡಿ ಎಂದಾದ್ರೂ ಏನಾದ್ರೂ ಅವ್ರ ಮೇಲೆ ಬೇರೆ ಡಿಸಿಪ್ಲಿನ್ ಎನ್ಕ್ವೈರಿ ನೋಟಿಸು ಅಥವಾ
Nothing of that
ಏನಾರ
sort.
ಇತ್ತಾ?
ಅದು ವೆರಿಫೈ ಮಾಡಬೇಕು. I will
ತಿಳ್ಕೊಂಡು ಹೇಳ್ಬೇಕು.
that I will.
There is no past history of any misconduct.
ಇಲ್ಲ
ಇಲ್ಲ sir.
ಎಷ್ಟು ಸರ್ವಿಸ್ ಮಾಡ್ಯಾರ?
He has been, my lords, from 2006, he has been, 2006 he was appointed, 18 years ago.
ಹಂಗ ಅಷ್ಟು ಬಹಳ ನೀಜರ್ಕ್ ರಿಯಾಕ್ಷನ್ ಇರಬಾರ್ದು ಗವರ್ಮೆಂಟ್ ಇದ್ದು. ನಾವು ಜಡ್ಜಸ್ಸು ಲಾಯರ್ಸು ಅಂತ ರಿಯಾಕ್ಷನ್ ಇಟ್ಕೋಬಹುದು.
Liars can have, my lords.
ನಾಟ್ ಗವರ್ಮೆಂಟ್. ಒಂದು ಸಣ್ಣ ಮಿಸ್ಟೇಕ್ ಆಗಿ ಏನಾರು ಅದರಿಂದ ಲಾಸ್ ಗೀಸ್ ಆಗಿದೆಯಾ?
ಅದು ವೆರಿಫೈ ಮಾಡ್ಬಿಟ್ಟು.
ಅದು ಓನ್ಲಿ ಥಿಂಗ್ ಈಸ್ ಒಂದು ಫೈನರ್ ಆಸ್ಪೆಕ್ಟ್ ಇದೆ. ನಾಳೆ ಎಲ್ಲರೂ ಹಿಂಗ್ ಮಾಡ್ಕೊತ ಕೂತ್ಕೊಂಡ್ರೆ ಮುಂದೆ ಚಾರ್ಜ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗೋದು ಹೆಂಗೆ ಅನ್ನೋ ಒಂದು ಫೈನಲ್.
After handing over the charge,
It was an election transfer, my lords. On
next day.
It was an election transfer. I was directed to report for duties at Mandya from Mysore. On 9th evening at 7:47, I have produced evidence of that. Then, my lord, the e-file movement, my lord, that is the most unmanipulatable evidence. It shows that all my files were transferred to the
On 12th.
to the idea of my incoming Shivaraj on 12th at 12:47 PM. 10:00 ಚಾರ್ಜ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿ ಅಲ್ಲಿಂದ 1 hour is ಮಂಡ್ಯ ಡಿಸ್ಟೆನ್ಸ್. ಅಲ್ಲಿ ಹೋಗಿ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. And all that he has done is not pursuant to an order passed by this court. There was a request from the Tahsildar as to whether Kata can be transferred. Then Kata normally, my lords, it is the duty of the Tahsildar. But because of some past background, my lords, they had said that all these survey number ಅಲ್ಲಿ
But you have approved.
Approved, I have forwarded the file to Deputy Commissioner. It was the second Saturday.
Anumodisi.
Anumodisi, no, man.
To
I have not
case,
anumodisi anything, man.
Case, we come to case, page 95.
Page
It is perhaps under the representation of people like such orders are made. This is considered, this aspect is considered by the division bench Justice Kumar in district election officer versus so and so and.
ಅದರಲ್ಲಿ ಸ್ವಲ್ಪ ಡೀಟೇಲ್ ಬೇರೆನೋ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅದು. ಅದು ಸೊತ್ತು ಮೈಸೂರು ಮಹಾರಾಜಿಗೆ ಶರೀರ ಸೊತ್ತಾಗಿರುತ್ತದೆ, ರೆಕ್ಟಿಫಿಕೇಶನ್ ಡೀಡ್ ಅನ್ನು ಮೈಸೂರು ಮಹಾರಾಜರನ್ನು ಎಲ್ಲ ಡೀಟೇಲ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದರ therefore it was not withdrawn. Suspension order.
ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಮಾಡಿದ್ದಾರೆ.
ಏನು ಮತ್ತೆ ಆ ಆರ್ಡರ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕಾಗತ್ತೆ ನಾನು.
That my lord, sir, the Sambo.
This is not ordinary. It's not a case of transfer at all. Because Justice Kumar says it is not a matter.
Yes,
of
that is not the central.
This one. But question is, during election period, it is like wartime period. There the officers should be very, very vigilant. Suppose if these things happen.
What he has done is my lord.
Judgment, Kumar
page-
Saib. Yeah, ILR 2039. District election officer, ಯಾವ್ದು ನೋಡ್ರಿ judgment ತೆಗಿರಿ. District election officer versus ಯಾವ್ದು?
That is not central, Central Election Commission versus Union of India. Where the division bench said, my lords, that it is not a transfer, it is a deemed deputation.
This one.
My lords,
Ordinarily, if it is a transfer, we can understand. But when you are being shunted out because of the orders of the Election Commission of India, it stands on a different footing. Immediately it has to be, it should happen. If he is not vigilant, he suffers by non-vigilance.
page 76 ಅಲ್ಲಿ the page 76 paragraph 4 is what the action that is complained of is taken.
ಲಾಗಿನ್ ಈ ಆಫೀಸ್ ತಂತ್ರಾಂಶ ಲಾಗಿನ್ ಐಡಿಯನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಕಡಿತವನ್ನು ಅನುಮೋದನೆ ಮಾಡಿರುವ ಅಧಿಕಾರಿ ವಿರುದ್ಧ ಶಿಸ್ತಿನ ಕ್ರಮವನ್ನು.
ಅದಲ್ಲ, the file, my lords, actually the file I am producing, page 76. What is it that I have done?
You exercise your power even after.
No, I did not exercise any power, my lords. I just forwarded the file to the deputy commissioner.
That you should not have done. You should have washed your hands.
Strict. My lords, if I had been relieved on 9th, yes, my lords, I have no answer, my lords.
No, not like that. It's not ordinary, leaving the office and going. It's a special case. That's how division bench treated. These are not matters of transfer at all. They stand in a different footing. Election Commission wants you to be shunted out at the moment. It should happen. Otherwise, it will have lot many other repercussions. The very object is to see
I quite see that,
is
my
the
lord,
law.
because those who have been there for long years, belonging to that same place, all those things.
Repercussions. ಇದು ಬೇರೆ ಯಾವುದೋ ಒಂದು ಆರ್ಡಿನರಿ ಟ್ರಾನ್ಸ್ಫರ್ ಇದ್ರೆ perhaps we would have agreed with you. But this is a case where
Lords,
you are
even
being
otherwise,
shunted
no,
out.
my lords. I was kept under suspension on 5th of.
They have considered. They consider your
No, my lords,
representation
they have not.
and they have rejected.
No, my lords.
to revoke.
5th of June, I was kept under suspension. Supreme Court says, my lords, on 3 months, if the charge sheet is not issued.
6 months ಅಲ್ವಾ?
Supreme Court ಹೇಳಿದ್ 3 months ಅಂತ. ಇವರು
Supreme Court
ಮಾಡಿರೋದು
6
6 months ಅಂತ ಮಾಡಿದ್ದಾರೆ.
There is another judgment where
ಅಲ್ಲ,
Supreme Court
that
said
is
6 months.
Amar Singh Chaudhary ಕೇಸಲ್ಲಿ
Hold ಮಾಡಿ.
what Supreme Court said was 3 months ಅಂತ ಹೇಳಿ, the charge sheet was not issued ಅಂತ. So far they have not
How long
issued
you
any.
want to continue in suspension? ಈಗ
Of
ಅವಾಗಿದ್ದಾಯ್ತು.
course.
ಏನ್ enquiry ಏನಾದ್ರು ಮಾಡಿದ್ರೆ ಏನ್
Within
reason
ಇನ್ನ
ಮಾಡಿ?
6 months ಅಲ್ಲಿ ಮಾಡಿ deemed to have been revoked ಆಗುತ್ತೆ.
6 months ಅಂತಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ಈಗ ಮಲ್ಕೊಳ್ಳಿಕ್ ಅಲ್ಲ ಅದು.
ಇಲ್ಲ ಮಾಡ್ತಾರೆ.
ಅದ್ರಲ್ಲಿ ನೀವೆಲ್ಲ ಆಕ್ಟಿವಿಟೀಸ್ ಏನೆಲ್ಲ
ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್
ಮಾಡ್ಬೇಕು ಅಂತ.
ಚಾರ್ಜ್ ಶೀಟ್ ದೇ ವಿಲ್ ಇಶ್ಯೂ ಇಟ್ ಲಾರ್ಡ್ಸ್.
ಇವು ಆಫೀಸರ್ಸ್ ನೀವು ಸಸ್ಪೆಂಡ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಮತ್ತೆ ನೀವು ಸಬ್ಸಿಸ್ಟೆನ್ಸ್ ಅಲೋವನ್ಸ್ ಏನು ಒಂದ್ ಪೈಸಾ ಕೆಲ್ಸ ಇಲ್ದಂಗೆ ನಮ್ ಪಬ್ಲಿಕ್ ಮನಿ ಅವ್ರಿಗೆ ಕೊಡ್ತೀರಿ ನೀವು. ಏನು ಅದಕ್ಕೇನು ಸ್ವಲ್ಪ ಬೆಲೆ ಇಲ್ವಾ?
ಆಮೇಲೆ if it ends in minor penalty, full 100% salary ಕೊಡ್ಬೇಕು.
ಆಮೇಲೆ ವಸ್ತು ಕೊಟ್ಬಿಡು.
And I am
ಏನು
sure
ಕೆಲ್ಸ?
for under
Why you have rejected
the guidelines stipulated by the government,
ask tell the
minor
government.
penalty ಬಿಟ್ಟು ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಇದಕ್ಕೆ.
ಒಂದು ಮೇಲ್ಕಂಡ ಪ್ರಭಾರ ಹಸ್ತಾಂತರಿಸಿದ ಸಿಟಿಸಿ ಪ್ರತಿ ಹಾಗೂ ಸಿಟಿ ಸೊ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ
ಅವ್ರೇನ್
ಆದೇಶ-
ಬೇರೆ ಆದ್ನು he has forwarded the file. He should not have done. He is not FDC. That's another
ಅಲ್ಲ,
thing.
ಅದ್ರಲ್ಲಿ ಹಿಸ್ಟ್ರಿ ಇದೆ ಸ್ವಾಮಿ, ಆ ಫೈಲಿಗೆ ಹಿಸ್ಟ್ರಿ ಇದೆ.
ಹೌದಾ? Then on the objection ಹಾಕಿರ ನೀವು?
Please, ಹಾಕ್ತಂದ್ರೆ.
ಹಾಕಿದಿರಾ?
ಇಲ್ಲ, ಹಾಕಿಲ್ಲ.
ಮತ್ತೆ ಒಂದು ವಾರದ ಹಾಕಿ ತಗೊಂಡು.
Please.
ಇಟ್ಕೊಂಡು ಕೊಡತ್ತ. All this matter after 2 weeks. First off, the government may file its statement of objections within 1 week after serving a copy thereof on the counsel for the petitioner.
One date we make.
Call it. Date ಕೊಡಿ ಅದರ ಒಂದು.
25th of November.
ಬೇರೆ ಮತ್ತೆ ಅವ್ರಿಗೇನು ಸರ್ವಿಸ್ ರೆಕಾರ್ಡ್ ಎಲ್ಲ ಸ್ಪಾಟ್ಲೆಸ್ ಇದಾವ ಅಂತ ಬೇರೆ ಹೇಳ್ತಾ ಇದಾರೆ ಅವರು.
ಅದೇ
ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. ನೀವೇ ಯಾರು ನಿಮ್ ಕಡೆಯವರು ಹೇಳಿ ಮಾಡ್ಸಿರ್ತೀರಿ ಅವ್ರ ಕೈಯಿಂದ ಇವೆಲ್ಲ ಆಫೀಸರ್ಸ್. ಎಸ್
Scene number 33, Prithvish MK, Government Advocate.
Yes.
ಇದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆಲ್ಲ ಹೋಗಿದೆ, ಆರ್ಡರ್ ಹ್ಯಾಸ್ ಬಿನ್ ಕನ್ಫರ್ಮ್. ಅದು ಇವರು ಮಹಾರಾಜರು ಅದು ಇದು ಅಂತ ದೊಡ್ಡದು ಮಾಡುತ್ತೆ. ಇದೇನಿಲ್ಲ.
Okay. 32. Ajit. 33.
Yes, let's appear for the petitioner. Let's have challenged the order imposing penalty of compulsory retirement on the petitioner.
Misconduct ಏನು?
The misconduct is of misappropriation of money.
Just amount.
Let's about 5 lakhs and odd, which is returned to the government. It is not permanently misappropriated. Charges
return to the government. Suppose if the thief returns the stolen goods,
yes,
whether theft will come to an end.
No, that is not the petitioner was a second division assistant. I'm only on the question of competence. And on merits also, I may have, there is some sort of an admission at the stage of evidence. May I just take your lordship through the documents? And
ಯಾರು competent authority ಅದನ್ನ ಹೆಂಗ್ issue treat ಮಾಡ್ಯಾರ?
Yes, the tribunal has not gone into. Your lordship may find the impugned judgment. It has not treated it at all.
Have you taken up that contention?
Yes, that was my specific case before the tribunal also.
Who is the competent authority?
In my submission, it is the government which is the competent authority.
Show that from the rules.
Yes, I have extracted the rules also. What happens is this, the joint inquiry with the petitioner and one other person who is a senior sub-registrar. I am a Group C officer.
Group C ಗೆ ಆಗಿದ್ರೆ ಸರಿ ಇರ್ತಿತ್ತು.
Group C
joint inquiry ಇರೋದಕ್ಕೆ ಆ
authority government ಮಾಡಬೇಕಿತ್ತು, ಇವ್ರು ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಅಷ್ಟೇ. That might be the sole saving grace, but the petitioner is a second division assistant. For 3 days, the money had come into his account instead of going to the government. Then the money is returned to the government. When charge memo is issued, I take up a defense saying that when it was
how it came to you?
When in the computer, when various accounts are there, in a series in the line, instead of depositing it to the government's account, it has come to my account. After the intervening,
that money was deposited by whom?
That stamp duty is paid.
Correct.
And then we have to deposit it to the government. So instead of going to the government, it had come to my account. After the intervening Saturday and Sunday, on Monday, it was returned to the government. On that allegation, charge memo I was placed under suspension. Charge memo was issued to the both of us. I took up a defense, even at the stage of reply to the articles of charge, that no, I have not misappropriated intentionally. Then, during the course of evidence, in one paragraph, my evidence is only one paragraph. In one paragraph, there's an admission saying that, yes, I have taken the amount because I was in necessity of it.
ಮತ್ತೆ ಇನ್ನೇನ್ ಬೇಕು?
Yes, there's
one line ಸಾಕದು, one paragraph ಹಾಕ್ಬೇಕಿತ್ತು.
ಹೌದು, but that would be contrary to what the defense that I had set up earlier, as well as the defense I set up at the time of giving my written arguments. Under rule.
You admitted.
In the evidence, there's that admission.
ಇನ್ನೇನ್ ಬೇಕು?
Yes,
admission.
Yes,
there's that section 30, 31 of the Evidence Act says,
yes,
admission shall not be a conclusive proof. But that is subject to 63 Supreme Court.
Yes,
where Apex Court equated it to conclusive proof only, unless you account for that.
Yes, more.
Hang explain madiri admission.
Admission, thereafter I take up a contention saying that at the instance of the senior sub-registrar, I was forced to take up that contention, and therefore I have taken up. In a departmental inquiry, such a contention, whether it would stand. But only 3 legal questions, one is on competence. Second one, I have taken a contention that originally it was an individual inquiry. Thereafter, you cannot convert it to a joint enquiry. Rule 11 cannot be.
ಅದು ಕರೆಕ್ಟ್ ಏನ್ ಪ್ರೆಜುಡಿಸ್ ಏನಾಗಿದೆ ಅದರಿಂದ?
That is what the tribunal says.
ಏನ್ prejudice ಇಲ್ಲ.
And the last contention that I have taken is, my lords, in the articles of charge, X number of documents were sought to be marked, but in the enquiry, X plus 1 number of documents are marked. Under CCA rules, they have to give me advance notice of 3 days and thereafter mark. The tribunal returns a finding saying that you have not objected to the marking. Therefore,
ಅದೇನದು ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್?
there are certain documents, that is the challan, so on and so forth, bank.
That's where is the question of all these things?
Yes, my lord.
When you admit
Yes, my lord.
that from that account to my bank account, money has come.
Yes, my lord.
You admit
Yes, my lord.
that I was in dire need of money and therefore I have taken that money.
Yes, my lord.
What else? What documents will do?
My lord, if in the totality of circumstances, my lord, it is looked into, my lord, whether, my lord, such admission would straight up.
Admission, yes.
Yes,
Read section, ಕೊಡಿ, evidence
my lord,
ಕೊಡಿ.
your lordship may kindly have page 106. my lord.
Read evidence ನೋಡಾಯ್ತು, ನಾವೆಲ್ಲ ಓದ್ಕೊಂಡ ಬಂದಿರ್ತೀವಿ ನಿಮಗೆ.
ಅಲ್ಲ 106 ನನ್ನ ಅಡ್ಮಿಷನ್ ತೋರಿಸ್ಬಿಡ್ತೇನೆ. 106 ನನ್ನ ಅಡ್ಮಿಷನ್ ಇದೆ. ಇಲ್ಲ I can't.
Section 30 ಅಲ್ಲ 31 ಇದೆ ಅಲ್ಲ.
Yes.
Admissions to be not conclusive proof ಅಂತ ಇದೆ, ಓದ್ ನೋಡಿ. ಅದನ್ನ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ಯಾರ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್.
Yes.
364, 67 series of judgments. You have admitted.
31.
If the thief admits,
Yes.
I have thieved the article, what else is required in a disciplinary inquiry? I had documented. Where do you take us to?
Yes, my lord.
Inter-alia case.
That's why, my lord, only on one legal question, my lord, I may have a case. Otherwise, my lords,
ಅದನ್ನ ಅವ್ರು ಟ್ರೀಟ್ ಮಾಡಿಲ್ವಾ?
That is not gone into such.
Com-
Here authority only has considered your loss.
Who has which authority?
Sub-regis for them.
Their authority ಅಂದ್ರೆ ಯಾವ ಡೆಸಿಗ್ನೇಟೆಡ್ ಅಥಾರಿಟಿ ಯಾರು? ಅದು
Government.
ಇರುತ್ತಲ್ಲ ನಿಮ್ಮ ರೂಲ್ಸ್ ಶೆಡ್ಯೂಲ್ ಏನೋ ಒಂದಿದೆ ಅಲ್ಲ.
government, my lords, in so far, if it's a joint enquiry, government, because the other person is a senior sub-registrar. If it was a individual enquiry.
ಅದು
my lord,
ಅವ್ರಿಗೆ
it is-
ಸಂಬಂಧಪಟ್ಟಂಗ ಮಾಡಬಹುದು ನಾವು.
ಅಲ್ಲ, joint.
ನಿಮಗೆ ಜಾಯಿಂಟ್ ಎನ್ಕ್ವೈರಿ ಇದ್ರು
Yes, Rule 13 says, my lords, that the highest of the authorities who is empowered, that will act as the disciplinary authority. My lords, I'm a second division assistant, my lords. Equities, my lords, may not have much place, but ultimately, my lords,
ಎಷ್ಟು ಸರ್ವಿಸ್ ಆಗಿದೆ?
my lords, I joined, my lords, service,
ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿದೆ, ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಇತ್ತು?
2012.
2012, I have a joint service, my lords.
Ah.
Impugned order, my lords, is passed in 2023, about 10 years of service.
10 ಕ್ವಾಲಿಫೈಯಿಂಗ್ ಸರ್ವಿಸ್ ಫಾರ್
ಇಲ್ಲ.
ಪೆನ್ಷನ್
15
years.
15 years, so ಆಗಿಲ್ಲ. My lords, as on today, my lords, I'm aged about 30 years. Money is, my lords, ultimately returned to the government.
No, that
Yes, my lord, I understand.
you
But
returned because it did not belong to you.
yes, my lords, yes, my lord.
It
But-
amounts to admission under section 58.
Yes, my lord.
If you
But
have returned money,
yes,
that amounts to admission that you
Admission.
have taken the money.
please, my lord.
Huh.
The allegation is that there was a temporary misappropriation for, my lords, a few hours, a few days. Therefore, my lords, whether, my
ಅಮೌಂಟ್
lords-
ಬೇರೆ ಯಾರ ಇಂಡಿಕೇಟ್ ಮಾಡಿದ ಮೇಲೆ ವಾಪಸ್ ಕೊಟ್ಟೆ?
ಇಲ್ಲ, ಇಲ್ಲ. Voluntarily, my lords, as soon as it was credited, I have taken up the defense in my written statement. When I checked the passbook, it had come to my account. When I got the message, and therefore I returned it immediately. I have set up that defense. If they can, my lords, take instructions and file their objections. Only on that context.
ಅಷ್ಟೇ ಪಾಯಿಂಟ್ ಇದೆ.
Yes.
Objection ಇದೆ. ಅಷ್ಟೇ ಪಾಯಿಂಟ್ ಅದು.
Disciplinary authority ಅಷ್ಟೇ.
ಅದು ಕರೆಕ್ಟ್. ಈಗ ಮತ್ತೆ ಈಗ ಮತ್ತೆ ನಾವು ಅವ್ರಿಗೆ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ವಾಪಸ್ ಕಳಿಸಿದ್ರೆ ಅದು ಒಂದು ಸಮಸ್ಯೆ. ಇವ್ರು ಹಂಗೆ ಬಿಟ್ರೆ ಮತ್ತೆ ಇದನ್ನ ಮಾಡ್ಕೊತ ಹೋಗ್ತಾರ ಅವರು, ಅದು ಇನ್ನೊಂದು ನಮ್ನಿ ಸಮಸ್ಯೆ ನಮಗೆ.
I'll give my unconditional undertaking that I will ensure that no such incident takes place. I will not misappropriate any further, and I will conduct myself in accordance with the conduct rules.
ಅದು ಲಾ ಹಂಗೆ ಇರ್ತದೆ. ನೀವು
Even in
ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡಬೇಕು ಅಂತಿರಲ್ಲ,
Right.
ಅದಲ್ಲ.
Yes.
ಅದನ್ನ ಒಬೇ ಮಾಡಿಲ್ಲ, ಇನ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಏನು ಒಬೇ ಮಾಡಿ.
Even in the absence of that undertaking is expected to.
That's what.
Like, he is, my lord, an SSLC pass, he is a SSLC graduate, and in the series of accounts, my lord, in while transferring.
ಬೇರೆ
there are series-
ಪಾಸ್ಟ್ ಕಂಡಕ್ಟ್ ಏನಿತ್ತು?
Nothing.
ಎಲ್ಲಿ ಹೇಳಿರಿ?
My lord, I have stated, my lord, in
Very-
paragraph number 1, my lord, of my application.
ಅಥವಾ ಇಂಥವೆಲ್ಲ ತಗೊಂಡು ಯಾರಿಗೂ ನೋಟಿಸ್ಗೆ ಬರಂಗಿಲ್ಲ ಜೋಬಿಗೆ ಹಾಕೋತ್ ಹೋಗಿರೇ ಯಾರಿಗೂ ಗೊತ್ತು.
My lord, without any notice, my lord, I have returned it.
Is it true? Without notice he returned that money?
Yes.
ಹಂಗಿಲ್ಲ some 47 ಅಲ್ಲಿ lordship may kindly say.
Monday,
47.
there day. Saturday, Sunday, 2 ದಿವಸ ಇಂಟರ್ವ್ಯೂವಿಂಗ್ ಇತ್ತು.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಡಿಸ್ಕಷನ್ ಮಾಡಿರೋದಿದೆ
ಎಲ್ಲಿ ಪೇಜ್
47 ಅಲ್ಲಿ ಇದೆ. ಅಪಾದಿತ ಮಹೇಶ್ ರವರು ದೇವದುರ್ಗ ಕಚೇರಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ 8 ಬಿಲ್ಲುಗಳನ್ನು ತನ್ನ ಸಹಿಗೆ ತೆಗೆದುಕೊಂಡು ಬಂದಿದ್ದರು. ಆ 8 ಬಿಲ್ಲುಗಳಲ್ಲಿ 2 ದಸ್ತಾವೇಜುಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟವು ಆಗಿರುತ್ತದೆ. ಸಿಂಧನೂರು ರೂಪಾಯಿ ಕೆಲಸದ ಒತ್ತಡದಲ್ಲಿದ್ದ ಕಾರಣ ನಾನು ಆ ಬಿಲ್ಲುಗಳಿಗೆ ಸಹಿ ಮಾಡೋದಕ್ಕಿಂತ ಮೊದಲು ಎಲ್ಲಾ ದಾಖಲೆಗಳು ಪರಿಶೀಲಿಸಲಿಲ್ಲ. ಈ ಮಹೇಶ್ ರವರು ತಮ್ಮ ಸಿಬ್ಬಂದಿಯವರಾಗಿದ್ದರೆ ಅವರ ಮೇಲೆ ನಂಬಿಕೆ ಮೇಲೆ ಆ ಬಿಲ್ಲುಗಳು ಸಹಿ ಮಾಡಿದೆ. ಶ್ರೀ ಮಹೇಶ್ ರವರು ಒಂದು ಸಾರಿ ಉಪಯೋಗಿಸಿದ ಚಲನ್ಗಳನ್ನೇ ಮತ್ತೆ ಉಪಯೋಗಿಸಿ ಪುನಃ ಹಣವನ್ನು ಇದಕ್ಕೆ ಪಡೆದಿರುತ್ತಾರೆ. ಈ ರೀತಿ ಡ್ರಾ ಮಾಡಿದ ಹಣವನ್ನು ಮಹೇಶ್ ರವರು ತಮ್ಮ ಸ್ವಂತ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಜಮಾ ಮಾಡಿಕೊಂಡಿದ್ದರು. ನಂತರ ಮಹೇಶ್ ರವರು ಫೋನ್ ಮೂಲಕ ಈ ರೀತಿ ತಪ್ಪಾಗಿ ಹಣವನ್ನು ಡ್ರಾ ಮಾಡಲಾಗದಿತ್ತು.
ಅವರೇ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ದು, ತಪ್ಪಾಗಿ ನನ್ನ ಅಕೌಂಟಿಗೆ ಬಂದ್ಬಿಟ್ಟಿದೆ, ಅದನ್ನ ಇಮಿಡಿಯೇಟ್ಲಿ ಏನು ಸ್ಯಾಟರ್ಡೆ ಸಂಡೇ ಒಂದೊಂದ್ಸರಿ ಹಂಗೆ ಮಿಸ್ಟೇಕ್ ಆಗ್ತಾವು. ಈಗ ಯಾರಿಗೂ ಗೊತ್ತಿಲ್ಲದಂಗೆ ಜೋಬ್ ಹಾಕೊಂಡು ಹೋಗಿದ್ದ ಅಂದ್ರೆ ಐ ವುಡ್ ಹ್ಯಾವ್ ಅಂಡರ್ಸ್ಟುಡ್. ಈ ಸೇಸ್ ಅವತ್ತು ಫ್ರೈಡೇ ಆಯ್ತಿದ್ ಇನ್ಸಿಡೆಂಟ್. ಸ್ಯಾಟರ್ಡೆ ಸಂಡೇ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಡೇಸ್ ಇದಾವೆ. ಅದೇನು ಸೆಕೆಂಡ್ ಸ್ಯಾಟರ್ಡೇನು?
I have not stated. I'll verify. Yes, I'll also verify.
ಕ್ಯಾಲೆಂಡರ್ ಚೆಕ್ ಮಾಡಿ.
Yes.
ಅಂತ ಇಮಿಡಿಯೇಟ್ಲಿ ಅವತ್ತಿನ ನಮ್ಮ ಸ್ಯಾಟರ್ಡೆ ವರ್ಕಿಂಗ್ ಇತ್ತಾ?
I'll verify. I have not verified.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
Yes.
ಗೂಗಲ್ಗೆ ಹೋಗಿ. ಆಮೇಲೆ ಅದು ತಪ್ಪುನು ಹೇಳ್ಯಾನ, ಹಿಂಗೆ ತಪ್ಪಾಗಿಬಿಟ್ಟಿದೆ, ನನ್ನ ಕ್ಷಮಿಸ್ರಿ ಅಂತಾನು ಕೇಳಿ.
ರಿಟರ್ನ್ ಮಾಡಿದ್ವಿ.
ಕ್ಷಮೆನೂ ಒಂದು ಫ್ಯಾಕ್ಟರ್ ಅದು. ವೆಲ್ಫೇರ್ ಸ್ಟೇಟ್ ನಲ್ಲಿ ನಾವು ತಪ್ಪು ಮಾಡಿದ್ದೇವೆ.
ಅಮೌಂಟ್ ಈಸ್ ಹ್ಯೂಜ್ ಲಾರ್ಡ್ಶಿಪ್.
ಎಲ್ಲಿ ಅವನು ವಾಪಸ್ 2 ದಿವಸಕ್ಕೆ ವಾಪಸ್ಸೇ ಕೊಟ್ಬಿಟ್ಟ ನಿಮ್ಗೆ. ಅವ ಹೇಳಿದಾನಲ್ಲಿ.
Where do you find actually how it was withdrawn and how it was?
ಹಾ,
ಅದು 46 ಅಲ್ಲಿ ಇದೆ ಸರ್. ಇದು ದೇವದುರ್ಗ, ಇದು ಮಹೇಶ್ ಕುಮಾರ್ ಬಿನ್ ಬಸವರಾಜ ಆದ ನಾನು ಕಚೇರಿಯ ರೀಫಂಡ್ ಬಿಲ್ಲುಗಳ ಮರುಪಾವತಿ ಹಣ 5,54,225 ಗಳನ್ನು ಪಾರ್ಟಿಗಳ ಬದಲಾಗಿ ನನ್ನ ರೆಸಿಪೆಂಟ್ ಐಡಿಯನ್ನು ಸೃಜಿಸಿ ನನ್ನ ಅಕೌಂಟ್ಗೆ ಹಾಕಿಕೊಂಡಿರುತ್ತೇನೆ. ಇದರ ಬಗ್ಗೆ ಉಪನೋಂದಣಿಕಾರರಿಗೆ ಯಾವುದು ಸುಳಿವು ನೀಡದೆ ಬಿಲ್ಲುಗಳಿಗೆ ಸಹಿ ಮಾಡಿರುತ್ತೇನೆ. ಇದು ಕಾನೂನಿ ಪ್ರಕಾರ ಅಪರಾಧವಾಗಿರುತ್ತದೆ. ಸದರಿ ಹಣವನ್ನು ಸಂಬಂಧಿಸಿದವರ ಅಕೌಂಟಿಗೆ ದಿನಾಂಕ ರಂದು K2 ಚಲನ್ ಮೂಲಕ ತುಂಬಿರುತ್ತೇನೆ. ಈ ತಪ್ಪಿಗೆ ನನ್ನ ಕ್ಷಮಿಸಿ, ಮುಂದೆ ಹೀಗೆ ಆಗನ್ನು ಹಿಡಿದುಕೊಳ್ಳುತ್ತೆ.
ವೆರಿ ಬಾರ್ಡರ್ ಲೈನ್ ಕೇಸ್. ಇಂಥವ್ರು ಬಿಟ್ಬಿಟ್ರೆ ಬೇರೆಯವರು ಇನ್ನು ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ. ಕೋರ್ಟಿಗೆ ಹೋದ್ಮೇಲೆ ಹಿಂಗೆ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೋದು ಅಂತ ಅನಿಸ್ತದೆ. ಇಂಥವ್ರನ್ನ ಇದ್ರ ಮೇಲೆನೆ ಮನೆಗೆ ಕಳಿಸ್ಬಿಟ್ರೆ ಅವನಿಗೂ ಅನ್ಯಾಯ ಆಗ್ತದೆ.
Proportionality, my lords, instead of compulsory retire.
ಮದುವೆ ಆಗಿದೇನು? ಮದುವೆ ಆಗಿಲ್ಲ. ಏನು ಏನ್ ಬಿಡುತ್ತೆ, ಒಬ್ಬನೇ ಇದ್ದಿ. ಬೇರೆ ಕಡೆ ಮಾಡ್ಕೊ 30 ವರ್ಷ ಅಷ್ಟೇ.
Yes. Any other punishment?
Compulsory retirement appears to be little harsher.
Leave it to lords.
ಏನ್ ಮಾಡ್ಬೋದು? ಪ್ರಮೋಷನ್ ಏನಾರ ಆಗಿದೆಯಾ?
Appointed as second division, till today as second division.
ಅದಕ್ಕೆ ದುಡ್ಡು ತೊಗೊಂಡಿಗೆ ನಾವು ಯಾರಿಗೂ ದುಡ್ಡು ಕೊಟ್ಟು ಪ್ರಮೋಷನ್ ಮಾಡಿಸೋಣ. ಒಂದು ಹೇಳ್ರಿ, ಎಂತಾದ್ರೂ ಒಂದು ಪನಿಷ್ಮೆಂಟ್ ಅಪಿಯರ್ಸ್ ಟು ಬಿ. ಸೆಂಡಿಂಗ್ ಹೋಮ್ ಇಸ್ ಎ ವೆರಿ ಏನೋ ಪಾಪಿಗೆ ಇನ್ನೂ ಅವನಿಗೆ ಬಹಳ ವರ್ಷ ಸರ್ವಿಸ್ ಇದೆ, ಏನೋ ಒಂದೊಂದು ಮಿಸ್ಟೇಕ್ ಆಗ್ತಾವು. ಮಿಸ್ಟೇಕ್ಸ್ ಡೂ ಅಕರ್ ಈವನ್ ವಿತ್ ಗಿಲ್ಟಿ ಮೈಂಡ್ ಆಲ್ಸೋ, ಅಲ್ವಾ?
It was voluntarily refunded by him.
ಹಾ,
that
figures in his favor, mitigating factor ಆಗುತ್ತೆ.
If he had refunded it or returned
After somebody
interviewing.
that would have understood. ಇದ್ರಲ್ಲಿ ಅಷ್ಟೊಂದು ಕರೆಕ್ಟ್ ಆಗಿ ನಾವು ಹಂಗ್ ಪನಿಷ್ಮೆಂಟ್ ಮಾಡಕ್ ಬರಲ್ಲ.
ಉಪಯೋಗಿಸೋದೇ ಇತ್ತು ಅಂತಂದ್ರೆ ಅವ್ನು ಯಾಕೆ ವಾಪಸ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು?
ಹಾ, ವಿದಿನ್ ಸಂಡೇ ಯಾವ್ದೋ ಟೆಂಪಲ್ಗೆ ಹೋಗಿ ದೇವ್ರೆ ಹಿಂಗ್ ಮಾಡಿದ್ದೀನಿ ಅಂತಂದ್ರೆ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಹಿಂಗ್ ಮಾಡಿದ ತಪ್ಪು ಹೋಗಿ ವಾಪಸ್ ಕೊಡೋದು, ಅದು that's another thing. He went for Sunday mass. There are English judgment that way. I went for Sunday mass and I prayed and Jesus told me to do this and therefore I came and confessed in the confession box. ಇದೆಲ್ಲ ಇದ್ರೆ ಬೇರೆ ಹಂಗೂ ಇಲ್ಲ. ಏನೋ ಒಂದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. ಆ ಟೈಮ್ money tempts everybody, almost everybody. I will not say
Due to lots.
Huh?
Due to lots.
ಒಂದೆರಡು
Allocation.
2-3 increment.
Lowest pay lots.
Lowest pay ಹಾಕಿ.
For increments.
So he is right.
With cumulative effect.
In the submission.
ಇಲ್ಲ, I will not write anything about that. Petition is partly allowed regarding head to mitigating factors, namely that soon after crediting the money to his account, he has remitted it back to the exchequer within a short span of 2 days, and those 2 days being Saturday and Sunday. First, this aspect of the matter has not been considered by the disciplinary authority. First, an order of penalty without adverting, passed without adverting to the mitigating factors ordinarily carries a lacuna warranting interference of tribunal bar court. Next point. The petitioner, having been appointed way back in the year 2012, has put in ಎಷ್ಟು service ಆಗ್ತದೆ? 11 years of service.
Yes.
About 11 years of service. And therefore, the remainder of service is too long. Too long. First off, had he put in the qualifying service for pension, that would have been a different factor. First off, the assertion of counsel for the petitioner that his client has spotless service records is does merit acceptance, there being nothing contra indicated from the records. First off, ours is a welfare state, and therefore in its action the elements of proportionality have to be reflected. Semicolon. The punishment should commensurate the gravity of the guilt, is a grand norm of penology, which aspect also has not been adverted to by the tribunal, as rightly argued by counsel for the petitioner. First, ಯಾವ್ದದು proportionality apex court decision ಯಾವ್ದದು 2006 or 7?
That I have relied on the judgment in Kuldeep Singh, 19. Kuldeep Singh I have relied upon.
Kuldeep Singh.
Proportional, yes. 1992 2 SEC page 10.
ಅಲ್ಲ, doctrine of proportionality ಮೇಲೆನೆ 2006.
I'll just hand over. Yes.
The apex court has discussed the doctrine of proportionality in AR SEC 2006. This is Thakur Cyber judgment alone.
Please, I'll hand over the. Yes.
Next part. In the above circumstances, this petition is partly allowed.
Yes.
ಯಾವ್ದು?
2006 2 SEC.
Correct. 2006 to ACC.
Page 276.
276.
3 SEC, I'm sorry. 3 SEC.
3 ACC. Okay. Not good. In the above circumstances, petition is partly allowed. The impugned order of penalty.
My contention.
ಅಲ್ಲಿ ಒಂದ್ಸರಿ AGA vehemently opposed. Okay. The penalty order having been modified, the substituted punishment of
Nalik increments.
of withholding of 4 increments with cumulative effect.
And lower pay.
Sakist is awarded. First up, we are mindful of the legal position that ordinarily levying of punishment belongs to the domain of the employer stroke competent authority, subject to all just exceptions. First up, in our considered view, the case is made out for interference by way of exception to the general rule. ಆ ರೀತಿ structure ಮಾಡಿ.
Lordships may note that this is in the facts and
Huh?
this is only in the facts and circumstances and not as a precedent.
It hardly needs to be stated that orders of judgments of this kind are not treated as precedent at all. All right.
Very well. I'm so grateful.
No, no course.
Number 34, Prithvish.
Not appear for the petition. Matter pertains to suspension.
Suspension.
Yes.
In ground.
That's the allegation, my lord, is that during the conduct of the elections.
Objection ಹಾಕಿದ್ರಾ?
No, my lord.
ಹಾಕಿಲ್ವಾ?
ಹಾಕಿಲ್ಲ.
ಮತ್ತ್ ಹಾಕ್ಬೇಕು.
The thing
ಯಾವ್ದು
last
ಹಾಕಿಲ್ವಾ?
This has to go for
Huh?
2 and 3. 2 and 3 notice has to go, my lord.
Issue emergent notice. Learned AG appears for respondents 1.
2 and
Emergent notice 2, 2 and 3. Respondents 2 and 3.
Like, great. Interim order is subsisting on the till today.
ಇದೆಯಾ?
I was
Interim
not,
order, if any, will continue till next date of hearing.
I'm deeply.
Okay.
35, Vijay Kumar.
Yes, Vijay.
Of dismissal without any inquiry.
Dismissal from service without inquiry. ಯಾವ ground ಮೇಲೆ?
On the ground, the caste certificate is false caste certificate. What happened was, my lord, she had obtained a caste certificate stating that she belongs to Kotayar community, which is held to be synonymous with Kotegar community. Pursuant to the government order issued, my lord, in 77. Subsequently, my lord, that order was withdrawn in 78. Not against
SC ನೋ ST ನೋ ಅದು?
SC.
SC.
In the meantime, my lord, the single judge held that the order of withdrawal may not be given effect to. At that stage, my lord, she obtained the certificate stating that she belonged to Kotegar community. My lord, she was appointed as assistant commissioner. My lord, on 17/6/2004, on a complaint, my lord, district caste verification committee, my lord, inquired into the matter and came to conclusion that I am not entitled to the benefit of SC. However, the caste verification committee said that I may be continued as a general category candidate without extending any benefit. But accepting that, my lord, the first respondent government proceeded to continue my services and granted promotion to the next higher cadre of Deputy Commissioner of Commercial Taxes. Thereafter, my lord, on a complaint before the Lokayukta alleging that I have obtained a false caste certificate, not a notice was issued by Lokayukta. But I submitted explanation stating that the verification committee has already recommended and has, based on that, I have been continued. Question of continuing does not arise. And my lord, the holding of inquiry by the Lokayukta would be impermissible. But at that stage, Lokayukta forwarded the matter to third respondent, CRE cell. But CRE cell straight away proceeds to recommend for dismissal from service, and based on that, I have been dismissed from service.
Well, correct. ಈಗ reservation.
In the meantime, my lord, in the meantime, this application, the writ petition was filed on 9/9/24, my lord. But on 28/8/24, my lord, the Honorable Supreme Court directed that the benefit of synonymous must be extended by protecting the services in view of one government order that was issued. That is, my lord,
ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ಏನದು?
ಇಲ್ಲ, identical. Kotayar community only. Lord, the association of the community approached the Supreme Court against the order of division bench. Lord, by this order, my lord, in view of
ಅದು ಈಗ ಶೆಡ್ಯೂಲ್ ಕ್ಯಾಸ್ಟ್ಗೆ ಶೆಡ್ಯೂಲ್ ಟ್ರೈಬ್ಗೆ ಅಂತ ರಿಸರ್ವೇಶನ್ ಮಾಡಿರ್ತಾರೆ. ಅದನ್ನ ಯಾರೋ ಒಂದು ಹಾರ ಹೊಡ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ
ಇಲ್ಲ, ಹಾಗಾಗಲಿಲ್ಲ ಸ್ವಾಮಿ. Here, government itself issued an order stating that you synonymous ಇದ್ರೆ ಕೊಡ್ರಿ ಅಂತ. On that basis, I obtained the certificate. Thereafter, my lord, caste verification committee came to conclusion that I am not entitled to because of
how
withdrawal.
that matter is treated by the tribunal.
Tribunal proceeds on the footing that the district caste verification committee has already held a inquiry. Therefore, question of holding one more inquiry doesn't arise.
paragraph.
My lord, in that, my lord, I was never given any opportunity to participate in the caste verification committee. I accepted it, and the government also accepted it in 2005, and they proceeded to continue me in service. And in fact, they promoted me to the higher cadre. After that, my lord, in 2012, after a lapse of 6 years, my lord, they proceeded to dismiss me from service merely on the recommendation made by the CR itself, my lord, which has no authority. My lord, the latest judgment, my lord.
Milinda is overruled.
Yes, my lord, Milinda is overruled, my lord, but in the instant case, what has happened is the benefit was extended.
Because of synonym order.
Yes. Your lordship may kindly come to para 35, my lord, of the judgment.
Where is the element of fraud?
Lord, this court had directed us to produce the caste certificate. Your lordships may kindly produce the caste certificate.
Fraud element
Alla, because my lord,
fraud
he
is we don't
Produced along with the
belongs
application.
to
It's-
Kottayar, my lord.
That is
When
not
we see the
disputed.
Caste certificate, my lord.
But synonym
He is synonyms illa. That is
But it-
what I am produced, my lord. Your lordships may kindly see in page.
On the basis of synonymous, this one, my lord, I have been given a certificate as Kotegar community.
No, good. Wait, they want to say something, na? Madam, ಈ last page
The
ಇರುತ್ತಲ್ಲ.
page 6 may kindly be seen.
ನೋಡೋಣ. ಸ್ವಲ್ಪ ಲಾಸ್ಟ್ ಪೇಜ್ ನೋಡಿ. ಲಾಸ್ಟ್ ಪೇಜು ಪ್ರೊಟೆಕ್ಟಿವ್ ಪೇಜ್ ಇದು. ಸಾಮಾನ್ಯವಾಗಿ ಈ ತೆಳ್ಳನಿಂದ ಒಳಗಡೆ ಇರ್ಬೋದು, ಹೊರಗಡೆ ಹಾಕಕ್ ಬರಲ್ಲ.
I'll instruct.
ಹಿಂಗೆಲ್ಲ ಹೇಳ್ತಿದ್ರು ನಮ್ಮ
I'll
teacher. ನಾವು 3ನೇ ಕ್ಲಾಸ್ನಲ್ಲಿ 2ನೇ ಕ್ಲಾಸ್ನಲ್ಲಿ ಇವನ್ನೆಲ್ಲ
I'll
ಹೇಳ್ತಿದ್ರು.
instruct my writ section, my lord.
ಅದು
Henceforth,
ಪ್ರೊಟೆಕ್ಟಿವ್ ಪೇಜ್. ಇದು ಗಟ್ಟಿಯಾಗಿ ಇರ್ಬೇಕು.
apology. My lord. Page 6, my lord.
Page 6.
Yes, my lord. Fifth one is called
ಬಂಜಾರ ಲಮಣಿ.
serial number
Lambani.
5, my lord. Kotegara.
ಕೋಟೆಗಾರ
Yes, my
A3.
lord. My lord, the petitioner, my lord, he is obtained the caste certificate by saying Kotegar, my lord. But he
Kotega.
belongs to Kottayar, my lord. It is nowhere synonym. It is nowhere equivalent to Kotegar, my lord. That is my submission.
ಅಲ್ಲ ಅದನ್ನ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಯಾರು ಸರ್ಟಿಫಿಕೇಟ್?
Tahsildar is issued. my lord.
ಕೊಟ್ಟು ನಾನು ಹೋಗ್ತೇನಪ್ಪ. ಐ ಆಮ್ ಎ ಬ್ರಾಹ್ಮಿನ್. ಐ ವಿಲ್ ಗೋ. ಐ ವಿಲ್ ಮೇಕ್ ಎನ್ ಅಪ್ಲಿಕೇಶನ್. ಐ ಸೇ ದಟ್ ಐ ಫಿಟ್ ಇನ್ ಟು XYZ. ಈಗ ನಾನು ಮೋಸ ಮಾಡ್ದಂಗೆ ಆಗ್ತದ? ನಾನು ಅದನ್ನ ಕ್ಲೇಮ್ ಮಾಡ್ತೀನಿ. ಅಥಾರಿಟಿ ಇಸ್ ಲುಕಿಂಗ್ ಇನ್ ಟು ದಟ್. Authority, what action you have taken against the authority?
That
Who
was
has issued-
cancelled. That was cancelled, my lord. Subsequently, there was a complaint made by one Venkatesh Bhovi, my lord. Thereafter, my lord, page 3, my lord, that caste certificate was cancelled by the Tahsildar, my lord. Subsequently, on 31/8/1991.
That certificate ಎಲ್ಲಿದೆ?
The page 1, my lord, first after the memo, my lord. Caste certificate is. This was issued on, my lord.
ಯಾವ ಕ್ಯಾಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ರು?
31/8.
Koteyar.
Illi Kotegar anta they have obtained.
ಕೋಟೆಗಾರ್ ಇದೆಯಲ್ಲ.
He belongs to Kottayar, my lord.
That is the
ಕೋಟೆಗಾರ್
synonym.
and ಕೋಟೆಯಾರ್
Never comes under SC, my lord. Kottayar barade illa.
ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? ಸಿನಾನಿಮ್ ಡಿಕ್ಲರೇಷನ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
Lord, that is stated in the judgment of the
Judgment
Supreme Court.
itself.
Judgment, my lord, your lordship may kindly come to the latest judgment which I have produced, my lord. At page
Para 33.
35, 33 and 30.
Huh?
35, my lord. My lord, it starts at 32, my lord. May I read?
Yes.
My lord, the circulars dated 11/3/2002 and 29/3/2003 were issued by the government of Karnataka, whereby protection was extended to the persons who had taken advantage of the caste certificate issued prior to the issuance of the letter dated 12/3/1987 by the Ministry of Finance, Government of India. Subsequently, the Ministry of Finance, Government of India, vide office memorandum dated 17/8/2005 also ratified this decision of the state and extended the protection granted by the government of Karnataka to the employees of respondent number 1 bank. On a close scrutiny of the official memorandum dated 8/7/2013, which was heavily relied upon by the learned counsel for the respondent, it transpires that the concerned authorities in para 3 of the official memorandum referred to only the government circular dated 11/3/2002 issued by the government of Karnataka for excluding certain castes from umbrella of protection. It states that the government notification dated 11/3/2002 relates to Parivar, Talwar,
ಇವರ ತಳವಾರ
Mal-
ಮಲೇರು ಕುರುಬಾ ಬೆಸ್ತಾ
Besta
and
and
ಕೋಳಿ
Koli
community.
community, whose members have obtained scheduled tribe certificate in this order.
Order. There
The
is
said-
no mention of
There is no
ಕೋಟೆಗಾರ.
mention of Kotegar.
ಅದು ಎಕ್ಸ್ಕ್ಲೂಷನ್ ಅನ್ನೋದು.
Oh, yes. Apparently, thus the above official memorandum was issued in ignorance of the government of Karnataka circular. date-
ಕೊಟ್ಟೆಗಾರ ಇದೆ ಇದರಲ್ಲಿ.
Next, my lord.
ಕೊಟ್ಟೆಗಾರನು ಇದೆ.
Yes, yes, it is there, my lord. Your
ಕೊಟ್ಟೆ
lordship.
ಯಾರಿದೆ, ಕೊಟ್ಟೆಗಾರ
ಕೊಟ್ಟೆಗಾರ
ಎರಡೂ ಇದೆ.
But,
Where do you stand by your argument? Ali,
Yes, my lord.
Government of Karnataka issued
Yes, my lord.
government, an order was issued, rightly or wrongly, it was issued. We feel that it is wrong. Okay. That was ratified by the central government.
Yes, my lord.
Subsequently, one more order was issued by the government saying that now ಆ ಮೊದಲನೇ ಆರ್ಡರ್ ನಲ್ಲಿ A, B, C, D ಅನ್ನು ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ವಿ.
Yes.
ಅದರಲ್ಲಿ B, C, D ಅನ್ನು ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಬೇಕು ಅಂತ. ಆ ಎಕ್ಸ್ಕ್ಲೂಡೆಡ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಕೋಟೆಗಾರ ಇಲ್ಲ, ಕೋಟೆಯಾರಿಲ್ಲ, ಕೋಟೆಗಾರಿಲ್ಲ. So whatever advantage based upon that government order is obtained,
Yes, my lord.
how can you say that it is a fraud? Fraud ಎಲ್ಲಿ ಆಗಿದೆ? Milinda is overruled now. Even then, in the overruling judgment where the apex, nam Devdas Sahebre ಒಂದು judgment ಮಾಡಿದ್ರಲ್ಲ ಯಾವ್ದು?
That is in-
He shall not be continued even for 1
Yes,
hour ಅಂತ
yes.
ಮಾಡಿದ್ರಲ್ಲ ಯಾವ್ದದು?
That is in the case relying on the
Ah.
national fertilizers.
Correct. That one. Where is the element of fraud attributable to the employee? ಆಗಿನ government orders ಎಲ್ಲ ಹಿಂಗಿದೆ, ಈ orders benefit ನಾ ತೊಳ್ತೇನೆ.
At that point of time, my lord, 91, when the caste certificate was issued, my lord, the petitioner was very well that, my lord, it was not included in the SC category, my lord, Koteyar, my lord. He belongs to Koteyar, caste certificate is Kotegar. How can he simply?
We understood that.
Yes, my lord.
Now, kindly come to page 20, para 33 of the judgment which Vijay is reading now.
Yes, my lord.
What he says, there is some sense. Please see.
Yes, my lord. On a close scrutiny of OM dated 8 July 2013, which was heavily relied upon the learned counsel for the respondent, it transpires that concerned authority in para 3 of the official memorandum referred only to the government circular dated 11th March 2002, issued by the government of Karnataka for excluding certain castes from the umbrella of protection. It states
ಆ ಎಕ್ಸ್ಕ್ಲೂಷನ್ ಕೆಟಗರಿಯಲ್ಲಿ ಕೋಟೆಯಾರ ಕೋಟೆಗಾರ ಇಲ್ಲ ಅನ್ನೋದು ವಿಜಯ ಆರ್ಗ್ಯುಮೆಂಟ್. Because Supreme Court has said that way.
Yes, ma'am. Apex court has.
Allow ಮಾಡಬೇಕಾಗುತ್ತೆ. How can you punish?
But my lord,
Where is the? And he said will be treated as general candidate, general merit candidate ಅಂತ, GM candidate ಅಂತ treat ಮಾಡಬೇಕು. Where is the culpability? Culpability ಬೇಕು.
At that
Mere
point,
wrong ಅಲ್ಲ. ಕಲ್ಪ ಎಲಿಮೆಂಟ್ ಆಫ್ ಕಲ್ಪ ಬೇಕು. ಅವಾಗ ಮಿಸ್ಕಾಂಡಕ್ಟ್ ಆಗ.
those candidates who were eligible under SC category were denied the.
Now that happens because of the action of the government. It happens. ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಗೊತ್ತು? ಏನ್ government does not commit any king does no wrong ಅನ್ನೋದು ಅದು ಇಂಗ್ಲಿಷ್ ಲಾದಲ್ಲಿ ಅಷ್ಟೇ.
In view of the judgment, my lord.
ಅದೇ ನಮ್ಮಲ್ಲಿ ಹೆಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ಅದು ಆಗಿದೆ ಅದು. It has happened now. Even king can do no wrong is given a decent burial by Crown Proceedings Act 1947 in England. The Crown Proceedings Act has been enacted, which recognizes king can do and he does commit mistakes. ಅಂತ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದಾರೆ ಸ್ಟೇಟ್ನವರು. Why we should punish that candidate? ಅಲೋ ಮಾಡ್ತೀವಿ ನಾವು. ಅದು ಈ ಎಲ್ಲ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಅನ್ನು ಕನ್ಸಿಡರ್. ಈ ಜಜ್ಮೆಂಟ್ ಇರಲಿಲ್ಲನೋ?
Iрлಿ. This was on 28/8/2024, my lord.
Okay. This came very subsequently.
Yes. I filed the writ on 9/9/2024.
Right. ನೋಡಮ್ಮ.
The lordship's kind permission, I have some instructions, can I?
ಕೇಳಿ.
ಒಂದ್ ವಾರ ಟೈಮ್ ಬೇಕು ಅಂತ.
ಏನ್ ಕೊಡೋದು ಹೇಳಿ ಅವ್ರಿಗೆ, ಅಂತವೆಲ್ಲ ಕೇಳ್ಬಾರ್ದು ಅಂತ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ. ಏನ್ ಇದನ್ನ ಮಾಡ್ಕೊತ್ಕೊಡೋಣ ಏನ್ ನಾವು? Record petition is allowed
Whether this
in the
list-
light of the observations made by the apex court at para 32 to 35. 35. First off, learned counsel for the petitioner is right in contending that misconduct by its very definition has to have the elements of culpa attributable to the delinquent employee, and that there are no such elements in the act of the petitioner in securing a certificate as Kotegara in the light of the orders of synonyms issued by the government of Karnataka and ratified by the central government. First, even the subsequent order of the state government excluding certain communities from the protective umbrella does not include inter-alia, Koteyar and Kotegar. Kotegar, comma, petitioner certificate mentioning Kotegara, Kotegar, Kotegar. First, we notice that the judgment of the apex court came in the recent past and it was not available when the tribunal decided the matter. First off, the benefit of judgments of the kind would avail to the petitioner in as much as the orders of synonym are always treated as retrospective. Yavadadu, Basavalinga power, which is that judgment. Synonym orders will be retrospective in operation and hold apex court. Be Basavalingappa, some judgment, I do not remember. Chapal Gaonkar on election law. Kalsi. Allowed. It is stipulated in Narshambarko. In fact, the government itself, having accepted the obtaining legal regime in this regard, had promoted the petitioner as
Deputy Commissioner of Commercial
Deputy Commissioner of Commercial
under general
Taxes.
category.
Under general category. General category. First, this apart, the submission of learned counsel for the petitioner that his client shall not stake any claim on the basis of social status as SC, ST, SC/ST, and that for all practical purposes, he shall be candidate of general merit.
Lord, she
shall be.
During pendency of the application before the tribunal, she retired from service to Lord. She had filed 2 applications seeking one more promotion to the higher cadre also. Lord, my prayer is to allow the application. Lord, since she has retired from service, all service benefit along with promotion to the higher post be considered. Lord, that was the prayer before the tribunal in second application. And I have sought for allowing that application also.
Reject
No, both the common order has been passed.
Merit mal consider madbekaಗ್ತದೆ application.
Lord, my junior has been considered promotion. Let that option be left open. I'll be permitted to make representation.
Petitioner having already demitted office on attaining the age of superannuation and retirement, comma, the terminal benefits in the post concerned has to be sanctioned and released to her within an outer limit of 3 months. 3 months. Failing which delay would carry interest at the rate of 1% for the first 2 months and 2% per mensem for the period next following, which may be recovered from the erring officials of the concerned department personally. Next paragraph. Liberty is reserved to the petitioner to relitigate in respect of her claim for higher position by way of promotion or otherwise as a consequence of our judgment made this day.
Please.
Okay.
My subject.
All contentions in that regard are kept open. Yes. AGA vehemently opposed on instructions of her claims. Okay.
For final hearing, number 36, Joshua Arjun Samuel.
Appear for the petitioner.
Yes.
My lords, may I request for a short passover, my lords?
Passover. 2017 matter for Yenidu.
My difficulty is that in 2 matters, there's a matter before court.
Some other day we'll have. Some other day.
I leave it. I'm ready today. My difficulty was in court number 2 matters.
Yes, no issue. That's call this matter week after next. At the request of counsel for the okay. Next.
Number 39, Madhukaram.
2-3 ಕೇಸ್ ಒಂದೇ ಸರಿಗೆ ರೀಚ್ ಆಗ್ಬಿಟ್ರೆ ಸ್ವಲ್ಪ ಟೆನ್ಷನ್ ಆಗ್ತದೆ ಯಾರಿಗೆ ಆದ್ರೂ. ಹಂಗಾಗಿ should be at ease. ಏನ್ ನಥಿಂಗ್ ಇದೆ ತಲೆ ಹೋಗುವಂಥದ್ದು ಎಂಥದ್ದು ಇರಲ್ಲ.
Apologize.
No,
I'm ready.
Need not. We don't subscribe to the view that the counsel is held up in other court is no ground for passover. ಅವನ್ನೆಲ್ಲ ನಾವು ಒಪ್ಪಲ್ಲ. ನಮ್ಮ ಕೋರ್ಟ್ ಪ್ರೊಸೀಜರ್ ನಲ್ಲಿ ಅವೆಲ್ಲ ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲಿ ಹೆಲ್ಡ್ ಅಪ್ ಆಗಿರ್ತಾರೆ. ಅಲ್ಲಿ ಬಿಡಕ್ ಬರ್ತದ? ರಾಜ್ಗೋಪಾಲ್ 10 ಕಡೆ ಹೋಗ್ತಾರ ಅವ್ರು. ಇಲ್ಲಿ ಬಂದು ಕುತ್ಕೋ ಕಂಟಿನ್ಯೂಸ್ಲಿ ನಮ್ಮ ಕೋರ್ಟ್ನಾಗ ಕೊಡ್ರಿ ಅಂದ್ರೆ ನೀವೇ ಕೊಡ್ರಿ ಫೀ ಅಂತ ಹೇಳ್ತಾರೆ ನಮ್ಗೆ ಅವರು. Yes. And the judgment of the Supreme Court said, the advocate is held up in, is not a ground and things are very difficult. Ali Supreme Court, it may be true. In High Courts, hangagalla. Yes.
This central government's writ petition.
Madhubaran Deshpande.
The issue is, my lords, I was an applicant for central civil services in the competitive examination held in 2016. I claimed reservation under OBC category and also physically handicapped. In OBC,
Vertical and horizontal.
Vertical and horizontal. I came within the cutoff marks and persons who are less meritorious to me were given service allocation and appointed.
You ready in the matter?
My lord, I appear for the R2. I'm only a formal party. The
Formal
UPSC has no role to play in this, except sending.
They have selected and they have recommended my name as recommended
They
for.
supported you.
Now, what is the central government declined to allot me any service on the ground that physically handicapped candidate can be allotted only physically handicapped reservation and he is disentitled for OBC quota, which is wholly contrary to the judgment of Supreme Court in Rajesh Kumar Daria, where it says, first you operate the vertical reservation. If a person, then draw up the list. In that list, if sufficient number of horizontal candidates are there, nothing further need be done. If there is a shortfall in horizontal reservation category, then my lords, knock out the persons from the bottom of that select list under the OBC category. To the extent you have to fill horizontal candidates.
Adagilla.
Adu madilla ante then my lord, the court tribunal directed that I be allotted to either Indian Foreign Service or Indian Revenue Service income tax within because persons who have ranked much lower for me have been granted that service. Then when the writ petition they came in writ petition, no stay has been granted. In spite of it, they have not implemented the order.
ನಾವು ಓದ್ಕೊಂಡ್ಬರ್ತೇವೆ ಒಳ್ಳೆ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಹಾಕೋಣ.
Next week.
ಪಾಯಿಂಟ್
ಇಷ್ಟೇ next week.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸ್ವಲ್ಪ ಹೆಲ್ಡಪ್ ಆಗಿ ಅದರ್ವೈಸ್ ಹಾಕೊಳ್ತಿದ್ದೆ. ಅದು ಯಾವ್ದಾದ್ರು ಮ್ಯಾಟ್ರಸ್ ಮೋಸ್ಟ್ಲಿ ನಿಮ್ದು ಒಂದು ಮ್ಯಾಟ್ರ್ ಇದೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಅಲ್ಲ next week ಅಲ್ಲ ನಂದು ಏನ್ one matter my lords have adjourned to 12th of November. Admission list ಅಲ್ಲಿ ಬಂದಾಗ that ಇದು dispose of ಆದ್ರೆ ಅದು automatically
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್ ಡಿಫಿಕಲ್ಟ್. ಅದು ಇದು ಆ ಬೆಂಚ್ನಾಗ ಇದೀವಿ, ಈ ಬೆಂಚ್ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ವಿ ಆರ್ ಇನ್ ಶಿವರಾಮ್ ಕಾರಂತ ಸ್ಪೆಷಲ್ ಆ ಕಾರಣಕ್ಕೆ. ಅದರ್ವೈಸ್ ವುಡ್ ಹ್ಯಾವ್ ಸೆಡ್ ನಂದು ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಆದ್ರೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಇಷ್ಟೇ ಪಾಯಿಂಟ್.
They were telling that one petition is pending in the Supreme Court. That has also been decided again in this central government.
Are you ready for arguments? Or you want time?
Saurav Yadav fully covers. That is the latest judgment.
It applies to physically handicapped also. Horizontal, you apply.
All horizontal reservations are identical. Only difference is some horizontal reservations are overall, some are compartmentalized. That will not make any difference in this case because that is not the contention of the other side.
20th ಮಾಡಿ. ಅವಾಗ at the request of counsel, the learned CGC, finally. ಇಲ್ಲ ಬೇಗ ಮುಗಿಸ್ಬೇಕು ಇವನ್ನ. ಹಿಂಗೋ ಹಂಗೋ ಒಂದ್ ಕಡೆ ಮಾಡಿ ಹಾಕ್ಬಿಡ್ಬೇಕು. They will, these people will know where we stand. ಬೇಕು ಅಂದ್ರೆ ಅಪೀಲ್ ಹಾಕೋತಾರೆ. But just with that.
3 years they took adjournment on the ground that one matter is pending before.
ಹೌದು, they took ಅಂತ ಹೇಳ್ಬೇಡ್ರಿ. We gave ಅಂತ ಹೇಳ್ರಿ.
ಅವ್ರು ಕೇಳಿದ್ರೆ ತಾನೇ
ಅವ್ರು ಕೇಳ್ತಾರೆ. ನಾವು ನೀವು ಬೇಕಾದ್ ಕೇಳ್ತೀರಿ, ನಮ್ಗೆ ಗೊತ್ತಾಗಂಗಿಲ್ಲ ಕೊಡ್ಬೇಕು ಬೇಡ ಅಂತ. ನಾವು ಕೊಡಲ್ಲಪ್ಪ. ಆರ್ಗ್ಯೂ ಮಾಡ್ರಿ ಅಂತ ನಾವ್ ಹೇಳ್ತಾ ಇದ್ದೇವೆ.
ಅಲ್ಲ
ಹಂಗೆಲ್ಲ ಹೇಳ್ಬಾರ್ದು
ಈ
ಅಂತಾನೆ.
ತರ ಹೇಳ್ತೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ವರ ಪಡ್ಕೊಂಡ್ರು ಒಂದೇನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ, ಅದು ವಜಾ ಆಯ್ತು, ಅದ್ರ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ವಜಾ ಆಯ್ತು.
20th ಮಾಡಿ
ಆಗ್ಬೋದು.
ಓಕೆ. ಆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೊಡಬಾರ್ದು, ಹಂಗೆ ಕೇಳಿದ ತಕ್ಷಣ ನಾವು ಕೊಡೋದಕ್ಕೆ ಇಷ್ಟು ಸಮಸ್ಯೆ.
ಇಲ್ಲ
Actually, ನಾವು ಕೊಡಬಾರ್ದು. ಈಗ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಏನಾಗ್ತದೆ, ಸಣ್ಣ ಸಣ್ಣ ಮ್ಯಾಟರ್ ಇದು ಇಷ್ಟೇ ಕೇಸು, ವಿ ಹ್ಯಾವ್ ಅಂಡರ್ಸ್ಟುಡ್ ಓಲಿ. ನೆಕ್ಸ್ಟ್ ಡೇ ವಿ ಮೇ ನಾಟ್ ಪರ್ಮಿಟ್ ಯು ಟು ಆರ್ಗ್ಯೂ, ಯು ಮೇ ಆನ್ಸರ್ ಅಷ್ಟೇ. ಬಟ್ ಎಷ್ಟು ಟೈಮ್ ವೇಸ್ಟ್ ಆಗ್ತದೆ. ಅದು ಮೊನ್ನೆದು ಇದ್ರದ್ದು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್ ಎಷ್ಟು ಹೊತ್ತಿನ ಮ್ಯಾಟರ್, ಎಂಟ್ರಿ ಮಾಡ್ರಿಗೆ ಅಷ್ಟು ಮಾಡ್ಬಿಟ್ರೆ ಬೇರೆ ಗತಿ ಏನು ಮಾಡೋಣ. ವಿ ಹ್ಯಾವ್ ಟು ರೇಷನ್ ಅವರ್ ಟೈಮ್. 3 ತಾಸು 4 ತಾಸು ಅದಕ್ಕೆ ಕಳೆದು ಬಿಟ್ರೆ ಟೈಮ್ನಲ್ಲೂ ಮುಂದೆ ಪಾಪ ಉಳಿದಂಥವ್ರು ಕ್ವಶನ್ ಇದೆ ಅದರಲ್ಲಿ, ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ ನಾನು. ಬಟ್ ಸ್ಟಿಲ್ ದೇರ್ ವಾಸ್ ಏನೋ ಒಂದು ಸಮಥಿಂಗ್ ರೇಷನಿಂಗ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡನ್. ರೇಷನ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡನ್. ರೇಷನಿಂಗ್ ಬೇಕೇ ಬೇಕಾಗ್ತದೆ. ಯಾವ ಮ್ಯಾಟ್ರಿಕ್ಸ್ಗೆ ಎಷ್ಟು ಏನು ನಾವೆಲ್ಲ ಹಾಗೆ ಉದ್ದಕ್ಕೆ ಹೋಗಕ್ ಬರಲ್ಲ. ಎಸ್
40 ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್
ಏನು ವಿಷಯ ಇದೆ?
Challenge the KAT order, my lord.
It has to be
He
listed.
had directed for reinstatement of the petitioner, respondent, my lord.
ಲೋಕಾಯುಕ್ತದವರು ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅದು ಒಟ್ಟಿಗೆ ಲಿಸ್ಟ್
Compulsory.
ಹಾಕಿದ್ದಾರೆ.
ಯಾವ್ದು
ರಿಟ್ ಪಿಟಿಷನ್ 26100 of 23
ಬರೆದು ಕೊಟ್ಬಿಟ್ಟು
26
100
along with WP number
of 23.
science.
Scope of judicial review, my lord. My lord's judgments are there.
ನೋಟಿಸ್ ಆಗಿದೆ ಇಲ್ಲಿ ಇದು ಆಗಿದೆ.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ.
ಇದೆ
ಇದೆ.
ಎಂಟ್ರಿ ಮಾಡರ್ ಟು ಕಂಟಿನ್ಯೂ ಅಂದ್ಬಿಡಿ.
Oblige.
ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡರ್ ಟು ಕಂಟಿನ್ಯೂ ಅಂದ್ರು ನಿಮ್ಗೆ ಸಪರೇಟ್ ಬಿಲ್ಲಿಂಗ್ ಮಾಡ್ತಾ ಅದು ಅಲೋ ಇದೇನು?
ಇಲ್ಲ.
ಇಲ್ಲ.
No, my lord.
ನೋ
No, my lord. Only.
ಎಂಟ್ರಿ ಮಾಡರ್ ಟು ಕಂಟಿನ್ಯೂ. ಎಲ್ಲ ಮ್ಯಾಟ್ರಸ್ ಮುಗಿದೋತಾ? ಹಾ, ಆ ಮ್ಯಾಟ್ರ್ ಇದೆಯಾ? ಓಕೆ. ಅಲ್ಲ next date of hearing. Interim order to continue.
Oblige.
Yes. All right, thank you. Vijay Kumar ಎಲ್ಲ ಎಷ್ಟು ಪರ್ಫೆಕ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್. Really we feel happy. ಟೈಮ್ ವೇಸ್ಟ್ ಇಲ್ಲ, ಟು ದ ಪಾಯಿಂಟ್. ಹಿಂಗೆ ಹಾಕಿ ಮುಗಿದು ಫೈಲ್ಸ್ ಕಳಿಸ್ಬಿಡಿ, ಮುಗಿಸ್ಬಿಡ್ತೀವಿ.
ಏನ್ ಮೇಡಮ್ ಹೋಗೋದ್ರಲ್ಲ ಹೇಳ್ತೀರಿ, ಅಪರೂಪ ಬರೋದು.
Court officer? Court officer?
ಹೇಳಿ ಕೇಳಿಸ್ತಾ ಇದೆ. ಕೇಳಿಸ್ತಾ ಇದೆ ಹೇಳಿ ಮೇಡಮ್.
Court officer. Court officer. Court officer. ಇಲ್ಲಿ ಅನ್ಮ್ಯೂಟ್ ಆಗೈತೆ ಅವ್ರದ್ದು.
Court officer.
ಅವ್ರದ್ದು ಮ್ಯೂಟ್ ಆಗೈತೆ ಮೇಡಮ್. ನಿಮ್ಗೆ ನೀವೇ ಮಾತಾಡಿದ್ರೆ ಕೇಳಿಸಲ್ಲ ಅವ್ರಿಗೆ.
ಅಲ್ಲ ಸರ್, ಅವ್ರು ಮ್ಯೂಟ್ ಆದ್ರೆ ಅವ್ರು ಮಾತಾಡಿದ್ ನಮಗೆ ಕೇಳಿಸಲ್ಲ ಅಷ್ಟೇ, ನಾವ್ ಮಾತಾಡಿದ್ ಅವ್ರಿಗೆ ಕೇಳಿಸುತ್ತೆ ಸರ್.
ಸರ್ ಹೇಳಿ.
ಹಾ ಸಾರಿ ಮೇಡಮ್ ಅವರೇ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದ್ದಕ್ಕೆ. ಈಗ ನೆಕ್ಸ್ಟ್ 6th ಕೋರ್ಟಲ್ ಮತ್ತು 6th 2:30ಗೆ ಯಾವ್ದು ಇದೆ ಮೇಡಮ್ ಅವರಿಗೆ?
3 ಗಂಟೆಗೆ
2:30ಗೆ
2:30 ಇದೆ ಸರ್, ಮ್ಯಾಟ್ರ್ ಇದೆ.
ಇದಾವ ಅದಕ್ಕೆ
41 and 42 ಇನ್ನೆಲ್ಲ ಮ್ಯಾಟ್ರ್ ಮುಗೀತು.
ಹೌದಾ? ಸರಿ ಮೇಡಮ್.
ಎಲ್ಲ ಮುಗ್ದೋಯ್ತಾ ಮೇಡಮ್?
Things have
Yes.
been notified.
Now, what the state has done is, in respect of certain posts, particularly like primary school teachers, they have made it a local, a district-wise unit for the purposes of recruitment. And what they do normally is, as I've been in this case also, simultaneous recruitment notifications are issued. There will be only one selecting authority. There will be only one competitive examination. But the drawing up of the merit list will be district-wise. In that district-wise, irrespective of where the district is situated, whether it is in Hyderabad, Karnataka region or outside that region, there will be again two cadres. One is a local cadre, then residual parent cadre. In that residual parent cadre, outside the Hyderabad, Karnataka region, that will be called as a state-wise local cadre or whatever we can do for a better understanding, but that may not be required also. Nothing in the also, then I get that type deputation and all I read to my lords. Then my lords, domicile, that who is the domicile of that area, local area, that is not relevant for the present purpose. Competent authority to issue certificate, reservation is a matter of direct recruitment, that para 8 I always already read to my lords. Then my lords, power to issue directions, power to authorize issue of directions, para 9. That will be relevant because in this, one of the contentions that is raised is the impugned circular has been issued on the basis of a decision taken by the cabinet subcommittee. That would take us to the transaction of business rules as to what is the power and scope of exercise of power by the cabinet subcommittee. Therefore, power to...
Sir,
yes, yes,
this order is a delegated legislation.
this order, and it says at para 10,
No.
provisions of this order shall have effect, notwithstanding anything contained in any act or rule, regulation or bylaw made thereunder before or after commencement of this order in respect of direct recruitment or promotion to posts under the state government or any local authority or body or...
That's the overriding effect.
Overriding effect.
We are asking you.
Yes, ma'am.
Do you call this as a piece of delegated legislation or subordinate legislation?
It is, my lords, it is
Because it has got normative character.
Normative character, and then, my lords, it is issued under a power vested in the governor by way of delegation under a provision of the constitution, that is 371J.
This is issued, read the preamble part.
Yes.
In exercise of powers conferred by clause 2 of Karnataka Order 2013.
This act, in exercise the powers conferred by clause 2 of the Karnataka special responsibility.
That order 2013.
Yes, ma'am.
Is presidential order.
Is presidential order, which is at page 415.
415. Whether that delegates power.
Yes, ma'am. It delegates power.
No, delegates power.
414.
To have this.
To the governors.
Governor.
Yes.
Can governor further delegate?
Governor, that is a question, Manoj, because he has delegated operational parts to it. But because Manoj as to how the options will have to be.
No, what we are asking is,
yes,
we have been taught.
Normally, Manoj, delegate cannot.
That's what, delegate ordinarily.
Ordinarily.
We only remember one particular doctrine which Professor Seshadri used to tell us in college.
Yes.
Delegatus non potestas, potestas delegare.
Yes.
So we are just asking, because you read out paragraph 9.
Yes.
Paragraph 9, power to authorize issue of that, whether that issue will arise or not. To my knowledge, that issue may arise in this case.
May arise, my lord.
So much is not stated in the pleadings, which I had seen yesterday.
Yes.
I feel like that.
In fact, in my petition, at least it has not been pleaded that governor could not have further delegated. Maybe that question may arise in this case.
Principal order. The principal order.
Principal order is, my lords, page 414. That is the presidential order, special responsibility order.
Is there any indication that governor in addition to doing this, he can further delegate the.
What it says in governor shall for the purposes of clause 1 have power to issue such orders as may be necessary. That means he will have to issue.
He has to.
He will have to issue.
But how can he further delegate?
That is
Is the question. Anyway, just kindly have this in your
I,
mind.
I will, that I frankly, my lord, I had not applied my mind, I would
Yes.
definitely do it. Because I had to go through what are the analogous orders approved under 371D.
Correct. If there is some indication.
Some
Otherwise
indication.
granting that
Yes.
power, then you can bank.
Most
upon that.
controversial of the special responsibility, the special provisions under 371 series is 371D. Because its birth itself is very, it came from.
Lot of birth pang.
Lot of-
Yes, it did not come one fine day.
Yes,
There
sir.
was a great agitation and that eventually led into issuance of this power, this order.
Yes, A.V. Narasimha Rao, my lords are aware of that,
That
A.V.
one.
Narasimha Rao.
Yes.
By that it came. This page 414, my lords. This is
414.
notification dated 24th October 2013. The following order made by the president is published for general information. In exercise of the powers conferred by clause 1 of 371J of the Constitution, the president hereby makes, with respect to the state of Karnataka, the following order, namely, this order may be called State of Karnataka Special Responsibility of Governor for Hyderabad, Karnataka Region Order 2013.
Therefore, it is special responsibility of the governor himself.
Of the governor himself. Clause 2, it shall come into force, subclause 2 is, it shall come into force at once. Clause 2, my lords, special responsibility of governor. The governor of Karnataka shall have the special responsibility for the establishment of a separate development board for Hyderabad, Karnataka region.
Is it in the governor of Karnataka?
Yes, my lord.
They are using that word, expression, na?
Yes, my lord.
Should we construe it in the light of Maruram versus Union of
Maruram, that is my lords, where the Lordship Justice Krishna here said,
that
governor
president
is shorthand form for the government.
and president is the shorthand.
President is a shorthand form of the, my lords, unless
that
there is unless there is anything
Contra.
to the contrary, governor should be presumed to be required to act on the advice of the
No, this
cabinet.
order we are asking. That's all right.
That's all, my
That has
lords.
been the law.
That
Now
should be
we
the,
are asking, the president would have said to the government.
that is where, my lord, the problem arises, even in interpreting this, because this order throughout uses the special responsibility order uses the word governor. Whereas, my lords, the reservation order which I read out to my lords, it at some places, most of the places uses the government. That is one aspect of the matter, my lords. So then the transaction of business rule says, if any notification is to be issued under a central law, it should be a matter to be decided by the cabinet.
No, that will not be applicable here.
That will not be, but the question still remains.
Of Parikar, it will not apply.
Yes, ma'am.
Your argument runs counter to Parikar.
Yes, ma'am.
Anyway, yes, all right.
This is, my lords, Hyderabad, Karnataka region, and for other matters referred to in clause 1 and clause 2 of Article 371J of the Constitution in respect of that region. So the first part of the delegated power to the.
The preceding provisions, 371J.
Yes, my lord.
Preceding provisions of that.
Yes, ma'am.
A, B, C, D, E,
Yes,
F, G, H, perhaps I also. How they are structured. And the orders issued under those articles, how they have been construed.
371, if my lords would kindly say.
This question has not arisen
This
at
question.
any point of time. Perhaps it has
Under
arisen.
371D, there must be an answer, my lord.
No, if this question.
Before this court, this question has not.
No, that's all. Under 371, it appears that what you say is true.
Yes.
But the other orders issued under 370 in the
371 in the.
ಐವರೆಗೆ
Yes, my lords.
ಅಂತ ಆರ್ಡರ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. how they have been interpreted?
That is, my lords, one judgment I have placed here, that is, that does not appear.
That does not answer that question.
That's one judgment, that is Surendra Reddy.
That does not answer
That does not answer that question.
Mr. Chandrasekhar, how do you answer that question? Any decision of any high court or of the apex court, the country?
As I have noticed, my lord, Surendra Reddy
should
was
be-
the only judgment, my
No,
lord.
there
with
it is not
reference to-
considered.
There it is not considered.
It's not neither argued
Surendra
nor
Reddy, the only question was whether,
Yes, sir.
once the recruitment process starts, whether reservation provisions can be changed.
There is another catch which will tell you.
Yes, ma'am.
If governor were to be construed in the light of Marura,
Maruram.
then how governor would part away his powers to the with the government?
That, my lords, in fact.
Therefore, if you say yes, you have one problem. If you say no, you have equal problem.
The point is not which answer is convenient to me. The
Ha.
question is,
How
what
legally?
is the correct position in law?
No, otherwise, where is the question of governor parting away his powers in favor of or with
My lords,
sharing it with the
first
government of the
question-
day?
The first question would be whether it would be a delegation.
Which one?
The governor authorizing the government.
It's a delegation only.
That is first thing, my lords. Second is,
No, sir.
it
Any,
is a delegation
it is a delegation going by
because,
Jain and Jain, IP Messi, SP Sathe, if
Yes.
and Basu.
yes,
If you see administrative law by these people,
Yes.
it fits into the idea of delegation only,
but
nothing
it-
else.
more so because
Paid.
here it says governor.
Governor shares part of his powers with the government of the
Yes, my
day,
lords. Yes, my lords.
which you already know.
Yes, my lords.
So
Uh,
how you are going to?
And in this, even Article 371J clause 2 itself uses the word governor.
That's what, therefore we are asking you now. Yeah, several parts of the constitution uses the word. Maruram enlists all those provisions.
Maruram, yes, my lord, see,
This question
it dealt
arises,
with the power of pardon.
but not only that, even that aspect is considered by the apex court in the state of Maharashtra versus KM Nanavati.
Yes,
That's not the point.
yes, my lord.
The point is, if this question arises because of the employment of the term governor, otherwise the question would not have arisen. Otherwise, how that question will arise? That's why.
No. What governor means is different.
Because
Here, the words
governor-
are used in,
Governor is not defined as such to my limited
it is
exposure
not.
to constitutional law, the constitution as
yes,
such.
yes, my lords.
But government is defined under the
General Clauses Act.
General Clauses Act 1897, which is made applicable to the constitution.
Yes, my lords. It is,
Because
meant-
317 ಯಾವ್ದು? 317 says the General Clauses Act 1897 shall be applicable for the
for interpretation of the constitution also.
Therefore, we are asking you now again.
There, my lord, state government is defined as governor. Governor is a state government in the General Clauses Act.
So ಬೇರೆ ನಮಗೆ define.
Take,
You had banked upon two decisions of, one was of Bombay High Court in that the chairman of pollution control, Sudhindra Rao versus state of Karnataka.
yes.
You had argued that. No, you had quoted those judgments before me. Yes.
There I said about the power to accept resignation. Who has to accept?
There you said, yes, but argued that matter before me.
Yes, my lord, yes.
There you have discussed that.
Yes.
If you take, because that will be relevant for us to know
Yes, my lord.
how,
I-
who is governor, what
I will
who
have
is
to-
government, that
I have to
aspect.
pick up my,
No, you only had argued. I know.
Yeah, I
remember
know,
because
but I'll have
authored
to-
that judgment.
I have to
Yes.
refurbish my knowledge of reconstructing what I argued
Correct,
there.
correct, correct. Yes.
Section 8. you know. Huh? State government is,
Under the state general clause. No, we have discussed now, it's affirmed by the Supreme Court, that, take out that, Sudhindra Rao versus state of Karnataka. ILR, the other one reported. Two paragraphs I have dedicated to treat your argument. No, I am not holding it to you because you are arguing other claims now. Case of other claims. You are not bound by what you had
I
argued
always
earlier.
believe, my lords, there is no estoppel against argument. This-
Government is defined there.
State government
Correct.
as respect anything done after the commencement of the constitution, commencement, and before the commencement of 19, that is, in respect of anything done or to be done after the commencement of the
Constitution.
Constitution 7th Amendment Act shall means in a state, the governor. State government shall mean the governor.
So this is the reverse now. State government is governor is one thing. Whether governor is state government is another, reverse of that now.
And more so the complication arises here because it uses the the word governor and state government
Separate.
very distinctively.
Where are that?
No, my lords, for example, my lords, clause 2 of Article 371J itself, my lords may take.
371J.
Yes, my lords. So that is at page 412. After Article 370, the following article shall be inserted. The President may, by order made with respect to the state of Karnataka, provide for any special responsibility of the governor for A, establishment of a separate development board for Hyderabad, Karnataka region.
Equitable allocation of funds,
Other-
equitable opportunities,
2B, my lords, if my lords would kindly see, there, my lords,
certification of.
there the word state government appears, clause 2B, which we are concerned with.
That order,
2,
that order is, the first one is the president's order.
yes, my lords.
The clause 2,
2,
governor's order.
Governor 2, an order made under subclause C of clause 1 may provide for reservation of proportion of seats in educational and vocational training institutions in Hyderabad, Karnataka region for students.
Students, education.
That B, my lords, their state government separately comes. Identification of posts or class of posts under the state government and in any body or organization of the control of the state government. Then comes the presidential special responsibility order. Here, my lords, governor may make an order regarding posts in the state, under the state of Karnataka. There may not be much difficulty to understand that because deciding power is vested in the governor. But if we come to the special responsibility order at page 414, it confers power only on the governor.
That's what.
Then, my lords, when we come to reservation order 2013, the powers are all delegated
To the state government.
by the governor to the state government or further an officer or authority appointed by the state government.
Governor is not defined in the constitution.
Governor is my lords, not defined.
Which is the provision where he is, where under he is appointed?
That is, my lord, governor is appointed under 100. My lords. The citizenship, state and the section, article 153, my lords.
One 153.
133.
153.
153. ನನಗೆ 133 ಹೇಗೆ ಓದಿದೆ ನಾನು.
This question is not resolved in the light of such orders.
One 154 vests the executive power in the governor.
No, 164 is equated to government.
164, it is 154. The executive power shall be vested in the governor. It is equated to the government, my lords.
Second in Maruram itself.
Then comes 160, 160, there is in charge arrangements. 161 is power of governor to
That
pardon. That has been
Pardon.
interpreted as
government's power.
government's power.
Executive power.
There is no other clause dealing with that.
This question is not considered in any.
Frankly, my lords, I did not apply my mind to that aspect. my lords.
Just when I was reading the papers, I felt how governor could share. If governor is the state, where is the occasion for the governor to share his powers with the?
Another reason is, my lords, if the ultimately the object of the president was to delegate it to the government, there was no need to use the two word governor and state government.
Clause 1 and clause 2.
Yes,
Of
ma'am.
371J.
Yes,
Ali, government of the state illadu.
The government in this under
State
the
government.
state government.
Employees in the state government.
That
public
is
employees.
understandable, but in the presidential special responsibility order, it is in relation to the state of Karnataka, one place. Then, my lords, the power is delegated to the governor, not to the government. That is one way of reading it. Another way of reading it is, governor is only head of the state who acts on the advice of the governor.
In this case, who has done this?
In this case, my lords, it is done by cabinet state government
Government.
as per the decision of the cabinet committee, cabinet subcommittee on reservations, which is one of the contentions raised is that cabinet subcommittee had no power to do it. At best, cabinet only could have done it.
Go to 370. 370, up to 371J and onwards they constitute one genre.
Yes, ma'am. 370, that is regarding
Special status to Jammu Kashmir.
Jammu.
Where they have used the word, kindly see.
All provisions of this constitution, as from time without any modification, shall apply to state of notwithstanding anything, the document, judgment, that is
Government of the state.
I have this,
expression used to government of the state. Earlier, prior to amendment.
earlier provision.
Now it is dead and gone is another thing. But just for juxtaposing the text.
Okay.
For some state, it is used as government.
Correct.
370 prior to amendment and region, 370. Prior to amendment. I am getting amended text. It is temporary provisions, unamended alle. Notwithstanding anything under the provision of the power of parliament to make laws, provided no such in concurrence with the government of the state. There throughout it has used government of the state, 370. 370.
In all 371.
Yes, my lords.
Leave 370. 371 to 371J.
Yes, my lords.
Governor of the state.
That is the
Then it is government. Government. It's
Here, my lords, reservation order has in fact been issued by the governor himself.
Governor himself.
Yes.
If it is government, governor cannot do.
Yes. But all subsequent
Governor.
orders of this reservation order,
AG. Who has promulgated that order?
this order is promulgated by the governor, annexure H.
This is
To the, on the aid and advice of the cabinet. It is not independently garner having excess powers.
Government has
Still
done
is
that.
a governor of
Government
issued
powers.
and tell you.
We have a separate 371 J cell also. But now that question not having arisen, I'll re-verify my lords and also make that submission. But the submission is, it is through the government.
Government has promulgated it.
Please.
Then what is meant by governor
Please. my lords.
sharing it with the government?
That is a fundamental question my lords have raised. In fact, as senior also pointed out, and my lords have said, if the answer is this way, it cannot be an answer which is convenient to the case. Rather, it has to be the right answer now.
The very whole 371J language,
Please,
just
please,
cursory reading.
Please.
It gives an impression that mongoose and cobra are kept together. But how harmonious, we do not know. Because there are other intricacies now. This take you during the course of
Luckily, my
argument.
lords, so far that situation has not arisen in this state yet.
Situational. That
Situational
question has not arisen.
Are they, mongoose and cobra have not started playing independent. Members, it has been issued, signed by the governor only, members. This annexure here.
No, issued by, he says, government.
Appears
Appears to be government.
No, it is at the end signed by governor of Karnataka.
It will be like that only. No?
By order and this one, governor of
Even
Karnataka.
otherwise. Even otherwise, it will be like that.
Yes.
We have not strictly adhering to in the name of by the order of, we are not strictly adhering to that after that famous judgment of Justice B.K. Mukherjee's judgment.
There, more or less, they said it can be proved by producing the contemporaneous records.
Therefore,
yes.
who says that very difficult there unless you answer. Please. Now you said extemper. You assumed it and said.
No.
You have studied and said.
No. I had argued very other matters also.
We are asking a question to you.
Please, my lords.
Are you making that statement after study or on your impulse?
I am on account of the having handled several matters. I'm sure of it that it is on the basis of this. I will re-verify that is what I'm saying.
You only make us to put one more question to you endlessly. It will go on. Please, we will not do that anyway.
Please.
Well, this difference between the governor and state government, this is required to be examined.
It has to be because if we come to the conclusion, no other high court in the country have examined it under 371 to 371 I. Where states is there?
How the maximum
question must have been examined.
Maximum litigation bandara 371D. I should be able to find out from the.
Suppose if we come to conclusion.
Yes.
In 371 text, governor means governor as such, as contradistinguished from government of the day. Then consequences will be.
Consequences will be very of a huge magnitude, except perhaps the actions taken by the government under the reservation order itself. For example, constitution of a local cadre is implementation of the reservation order without adding to the guidelines already contained in reservation order. Suppose in the guise of implementation, state has added its own, in the which way my lords may hold, is not really in the manner of mechanics, but changing the structure. So mechanics means calling for options. It is there in reservation orders. Then giving opportunity, it is there in the reservation order.
There is one small thing. Government acting like a quasi-legislative body because of delegation.
Yes,
is one thing. Government acting as the executive body is another. That difference is maintained in constitutional jurisprudence, especially after Re-Delhi Laws Act. So many judgments. That impression we gather. I think a whole lot is dedicated.
And in this particular case, there is also perhaps an underlying reason why governor and state government were separated for this reason. Yeah. A political executive
because this is a matter pertaining to employment,
yes,
perhaps education also.
education also is there.
Also, because for students, etc., it is there, but in this case, it will not arise. The regulating service conditions of the employees of the state,
Is under Article 309.
309,
Yes,
and if it is a statutory power, legislative power,
yes.
under which entry it falls.
It is entry 43 of list 2, if I remember correctly.
Let's see.
Under list 2, it comes under 7th schedule list 2. Sorry, not 40. 41, man.
41.
Entry 41, list 2. State Public Service Commission, State Public Service of
41.
41. This, I.
Yeah. Very fast. Seven. Yeah, 2018 constitution ಕೊಟ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? State ಮಾಡ್ಕೊಂಡಲ್ಲ. State Public Services, State Public Services, State Public Service Commission.
Yes, ma'am.
41.
Yes, ma'am. The constitutional provisions governing the state public services are in part 14.
ಅದಕ್ಕೆ ಅಲ್ಲಿಗೆ ಹೋಗೋದೇ ಇಲ್ಲ ನಾವು.
ಅಲ್ಲಿ ಅದರಲ್ಲಿ it uses the legislature and governor is the two words are used. There model governor has been interpreted as in Maruma.
Okay.
But here because
63 one ಸರಿ ತಾವು ನೋಡಿ.
63 ಆರ್ಟಿಕಲ್ ಕೊಡಿ ಅದನ್ನ ಕೊಡಿ. Anyway, it is consistent with our being always lagging behind, na? So. 63.
But I don't subscribe to that view. A lot of the courts are
Okay.
behind schedule.
163.
163.
800. Council of Minister 800 advised to power.
63.
That is executive functions.
Correct. Aid and advice.
Clause 2.
If any question is whether any matter is not a matter as respect which the governor is by or under this constitution required to act in his discretion, the decision
is
of the
the-
governor in his discretion shall be final. And the validity of anything done by the governor shall not be called in question on ground that he ought or ought not to have acted in his discretion, where he acts in his independent capacity,
Except in so far as he is
considered by the apex court.
required.
In that Bihar, that Ram. Huh? No, that Bihar's, that power of the governor's judgment, na? Huh?
VP Singhal is it is a pleasure
Famous
tenure.
Constitution bench judgments. Huh? Rameshwara Dayala yadadu. Huh?
ಯಾವ್ದು?
Rameshwara Prasad. Rameshwara Prasad versus Union of India. Right. That is considered.
Where they prohibited the state from organizing into a union. Rameshwar Prasad. I have 1959.
No, that is Kameshwara Prasad.
That
which
is Kameshwar
Ambedkar
Prasad,
ji had
state
a-
government employees
So
right to
that-
unionize.
This is Rameshwara Prasad, Rameshwara Prasad or Sameshwara, there, something is there. no?
Rameshwar Prasad 4 anteno ನೋಡಿ, capital A, capital B.
Kameshwara Prasad. Bihar-
That is
Bihar
old,
State.
man, that is right to organize, right to unionize. Or we call it right to association, because union was a
No, there is
taboo then.
another Kameshwara Prasad,
Yes, man, I,
which Dr. Ambedkar had argued.
Yes.
That Kameshwara Prasad, state of Bihar, the Bihar Agrarian Reforms Act.
that
That
is
is
the-
validity, not that. This is a Rameshwara Dayal antena irbekala idu. This aspect is considered. Perhaps that, as Chandrasekhar has pointed out, if this is kept in view, rest of the things will fall apart.
only question is, my lords, whether it is a matter falling under second part of Article 163(1). That is where
163.
it says, except insofar as he is by or under this constitution required to exercise his functions or any of them in his discretion.
Correct. No, that is clarified in 2. 2
If any
takes it
question,
further. If that question arises, whether power is with the state government or with the governor, governor's decision shall be
final.
final ಅಂತ. But ಅಲ್ಲಿ ತನಕ ಹೋಗಿಲ್ಲ ನಾವು.
But governor's
question-
decision is a final ಅಂತ ಹೇಳೋದಕ್ಕೆ,
ಅಲ್ಲ, there is another
whatever may be
aspect.
the finality attached to it.
No, we are asking now, since you have pointed out, if the question arises, whether this power is with the governor or with the government, then can we decide that? When there is special
When
provision?
governor himself signs this order in his name, not in the name of the governor, your lordship will kindly see, my lord, that government order. H.R. Bharadwaj, governor of Karnataka.
No, we'll assume that it is like that only. There are two things under the transaction of business rules,
Yes.
where other than the governor is doing,
Lord, if,
the officer will say in the name of, on the order of.
Lord,
But where
if it
the
is,
governor
if
himself
it is,
does.
if it is the exercise of power, my lord, executive power, then it will be, my lord, in the name of governor, that will be usually, business transaction will come into operation. My lord, when he is doing himself, my lord, by virtue of, my lord, power given under 371J, then, my lord, it is the governor himself. He can take the aid of the government or the ministerial staff, my lord, it's a different matter. When he is doing himself, Lord, the question of saying, my lord, that it should have been done by the state government, my lord, may not arise.
No, in fact, confusion arose, much confusion is added, because if he stand, that governor has, government of the day has promulgated the policy in theory.
ಅಲ್ಲ, reservation order is issued by the governor. Rest of the orders that have followed, local cadre and all that, they have been issued by the government.
In the reservation order
How to?
of 2013.
Because governor has authorized the state
Other-
government under that particular.
Under that particular.
Signed by the governor, then below that it is by and in the name of the governor of Karnataka, signed by the joint secretary of the Hyderabad Karnataka cell, then.
Yes, government has done that.
Please.
The two may not go together, one
That
governor signing and then
Ah,
somebody
there is
else signing.
contradiction.
That is a contradiction in terms.
All right. No, now the other question
Yes.
arises because Chandrasekhar pointed out. 163, 1 read with 2.
Yes.
If that question arises, it is for the governor to decide, not for this court to decide. Yes.
Now,
163, 2. We cannot decide that. Because constitution says that he should decide it. Whether his decision is right or wrong can be adjudicated by us.
yes,
But the initial decision has to be taken by the governor himself.
whether it comes under the power of the government at
Governor-
all
Yes.
is a thing that is to be,
Suppose if that question now, if you raise that, it is like civil court referring whether land is tenanted or not. Civil
To the
court will
land
refer it
tribunal.
to the tribunal. That way we have to do it now, if in the event, because that question will eventually arise.
I would try to
Make
find
research.
I would like to apply my mind and then come back, Manoj, because I don't want to venture any,
Correct.
because it is a substantive question and I should not be found putting wrong foot forward.
Yes.
No, my lords, let me take my lords to keeping this question
apart.
in the background. I don't want to keep it aside, but in the background, right from the beginning. There are two things, my lords, in this reservation order. I would like my lords to this one. 10 is, I read out that it will have overriding effect. Then, my lords, para 11, removal of doubts. Who can remove the doubts?
That,
For this,
whether governor is saying the
governor is
non-obstante clause is by the governor. He has promulgated it.
impugned order is not promulgated with the governor. It is under executive order passed under 1666.
No, it is under the power which the governor has shared with the government.
With the government. Again, the question is, who in the government ought to have taken a decision?
That will.
That we will have to apply our mind. And then, my lord, there is a power to.
No, we asked you.
Yes, sir.
Whether that question will arise or not, we do not know. You read that overriding provision?
Overriding provision is a para.
Non-obstante, like 10.
Page 423.
That is by
para
the governor.
10.
Governor does it.
What he says is provisions of this order.
This order means which order? Which one?
This
we
is the
are
reservation
promulgating?
order.
No, that what we are asking you now.
Yes, my lord.
Can he do that? The president perhaps arguably, because it's an extraordinary power under 371J, because of so many things which
Yes.
constitution makers had not contemplated in the changed scenario, maybe that they have done. But whether that question will arise in this case, perhaps it arises.
It arises because this arises, my lord, because overriding effect may. If any subsequent order of the state government is
By subsequent, earlier also. Existing order in existence.
If it is contrary to this order,
Ignore that.
which has to, for example, my lords, one of the contentions that may be canvassed by us is that the very order which is challenged, that is the circular that is challenged or notification of February 2023, which is the subject matter of challenge. Whether it is in consonance with the reservation order will have to be examined.
Then that question arises.
Because several contentions are raised, one of the contentions is it is contrary to reservation order. Therefore, this overriding clause may find place in our submissions at some point.
Why we are telling that is, of course, that question will arise, not just academic.
Yes, sir.
That question will arise because there are other instruments that govern reservation, roster, so many things.
Yes, sir.
This governor's order says, if they run counter to the order which I am making,
all of them will go.
That, in our opinion, we are just thinking aloud. We are not
Whether it is
saying-
overreach of the power.
That power can be given to the parent. The delegate cannot arrogate to himself a particular power which the parent has not reserved for him.
The presidential order, I do not find any such.
President could have said, any order which the governor would make shall override all contra orders. We could have understood.
It is
How
not
can the
said-
delegate say,
Whether
my
it-
order, you have to obey, rest of the things.
All that the presidential order says that
Governor
you
will
can
do this,
make special provisions
Correct.
to the extent permitted by 371J.
It's more or like a blank check it is.
And then, my lord, 371J, another aspect that that would be visible from reading of 371D and J is 371D is, it has notwithstanding anything
That is not there in 371J.
that is not there in 371J. Therefore, 371J will be subject to all other provisions of the Constitution.
Otherwise, non-obstante would have occurred there.
Yes, Lord. 371D has used that non-obstante clause.
371H uses, 371G uses.
371J does not have.
71I uses it up to perhaps almost every,
Almost every special provision has that,
just the word, expression.
except 371J. 371J, 371 I also says, notwithstanding anything.
From A it begins.
From A to I it is there.
371D does not have.
371D it does not have it in the beginning, but if you are if my lords read that provision fully, that is traceable.
Nine is sectarian. 9 uses notwithstanding, but sectarian. It's not that way.
Yes.
It does not completely eclipse. Only in a matter of certain, no appointment, posting, promotion. Made
10, clause 10 of it.
10.
The provisions of this article and of any order made by the president thereunder shall have effect. Notwithstanding anything in any other provision of this constitution or in either law for the time being.
That overrides even other constitutional provisions also.
Yeah, yes, Manus. Clause 10. 371J. In fact, my lords, my first opinion when this came and was that when some employee groups came, I told them that, look, this is subject to Article 14, 15, 16, everything will, because this is the only special provision which does not contain that non-obstante clause.
No, that was hastily, it appears that way. There are such comments also.
In fact, my lords, what happened there was,
introduced.
the bill, the amendment was referred to the parliamentary committee.
Joint Select Committee.
Parliamentary committee report bandaga. Next day, this was placed without even incorporating the concerns expressed by the parliamentary committee on 371J. I remember one of the lacuna pointed out was that this does not have non-obstante clause. But yet they had to adopt and then.
So rest of the instruments.
Yes, madam.
That are in obtainment.
Yes, madam.
Any order will be subservient to those.
Subservient to this.
From that, what turns out in your argument?
It turns out for this reason. The reason is, when once a local cadre is constituted, admittedly it has been done, it has to be treated as a separate recruitment and it has to be a separate unit. Therefore, the question of one person opting for one cadre or the other cadre, when it is a joint notification, it will be restricted to only one recruitment. Because either you apply for local cadre or you apply for state cadre. 6/6/2020 circular validity has not been challenged. Circular.
What is that circular?
That is, my lords, which said that where there is a recruitment notification, persons who are eligible to claim reservation under local cadre, they have to make a choice whether they are applying for local cadre or for residual parent cadre.
Who is the author of that circular?
That circular is, my lord, 66 page 1. Yeah, 133. Yaar author?
Who has issued that?
That is issued by the it is not even expressed in the name of the governor.
No, circulars need not be expressed.
But it is issued by Special Cell, Hyderabad, Karnataka, DPAR.
Special Cell.
Special Cell.
What is its authority.
They have made, it appears, my lords, one separate cell for overseeing.
Appears ಎಲ್ಲ ಯೂಸ್ ಮಾಡಬಾರ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ನಲ್ಲಿ.
ಅಲ್ಲ,
It's very important matter. You can't say appears, I feel like this.
no, it is, my lords, it is by the DPAR only.
What is his authority?
The authority is under the executive power only.
Sure. Executive power cannot be used that way. If you go to Ramjavaya, the government has to issue it, not some unless
That
power
way,
is
my lords, even the,
allocated to him under the allocation of business rules.
that
we
is
have to
correct.
show.
my lords.
That we have
I
to show.
quite see, my lord. In fact, the impugned circular,
That circular is challenged.
6/6/2020, nobody has challenged.
No, since you said impugned circular,
Even that is 1/2/2003, that is challenged.
challenge, that is challenged.
That is challenged.
If I may interject, I have challenged 6/6/2020 in my matter,
On the ground,
that it runs contrary to the governor's order,
not on competence.
not on competence.
No, you're asking the competence.
Yes, but the submission was made, nobody has challenged it. I have challenged it on the ground that it runs contrary to the governor's order
Of course.
by giving options itself, because they have to be treated as separate units. There is no question of option at all.
But that was challenged after participating in the recruitment process.
Now, what is the authenticity of this circular? A circular authenticity prima facie, ನಮಗೆ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಬೇಕು ನೀವು. ಮುಂದೆ rest of whether you can't bank upon it, whether it is invocable, for rest of the things will follow. What is its authenticity? What is, how special cell is constituted?
Special cell is constituted, my
What
lord.
instrument?
That is an internal order passed by the minister in charge, who is the chief minister.
On what
This is my
basis?
information, my lords.
ಹಂಗೆ ಹೇಳಿದ್ರು ಅದು.
ಅದು it is that the state would be able to say that
Everything will be examined by us now. ನಾವ್ಯಾವುದೋ ಒಂದು ಸೆಕ್ಟರಿಯನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಂಗೆಲ್ಲ ನಡ್ಸಂಗಲ್ಲ ಇಲ್ಲಿ. ಕಂಪ್ಲೀಟ್ ಉತ್ತರ ಕೊಡ್ಬೇಕು
the
ನನಗೆ.
state has to say, my lords, as to who has constituted this cell.
It's a very important matter.
Yes.
Very important matter. The object is to give effect
I
to
request my learned
371J.
friend to provide this book, my lord. It contains every circular, every order.
Providing.
ಕೊಡಿ.
ಇಲ್ಲ.
ಸರ್ಕ್ಯುಲರ್. ನಂತರ ಬೇರೆ ಹಂಗೆ ಕೊಡಿದ್ರು ಕೊಟ್ಟರು ಆಗಲ್ಲ ಅದನ್ನ. ಯಾರು ಮಾಡಿದ್ರು?
Please.
ಯಾವ, what is this authority to do it?
ಇದೆ ನೋಡಿ.
Let's,
Any administrative law question, who issued it? What is his power?
And what are the, and then what are the powers conferred on that cell?
That's what.
let's
Therefore-
Hyderabad Karnataka cell, we will, let's place all the submissions, let's,
Because that is challenged also by Padke.
please. Now, my lords, Hyderabad Karnataka cell, under the transaction of business rules, is part of the DPR insofar as the powers is concerned. This notification, my lords, is issued by the Department of Personal and Administrative Reforms. It is incorporated, my lords, in the allocation of business rules Schedule 2, Hyderabad Karnataka cell, all matters connected to. So DPR, my lords, is the administrative department under the transaction of business rules for Hyderabad Karnataka.
Yeah, allocation of business
Please,
ಆಗಿದೆಯಾ?
agide.
So that will be the authority to issue.
That Schedule
that
2
will-
has been amended.
Amended, it has been amended.
Schedule 2. and
Amended.
To 371J,
Please, my lords.
order issued under 371J.
Please, my lords. And it reads that all matters connected with the implementation of 371J of the Constitution of India, other than matters allocated to planning program, and all matters pertaining to administration of Karnataka public employment reservation and appointment for Hyderabad Karnataka Region Order 2013. That is the subject that is given.
There one question that would arise is, my lords, it is constituted to oversee the implementation. If I borrow the words of the additional advocate general. Whether such a cell can
Issue such instrument.
issue such instrument, because overseeing the implementation,
ಏನಂತಿದೆ read ಮಾಡಿ?
Our Hyderabad Karnataka Special Cell. 1. All matters connected with the implementation of Article 371J of the Constitution of India, other than the matters allocated to planning, program monitoring and statistics department, education department, labor department. 2. All matters pertaining to administration of the Karnataka public employment within bracket reservation and appointment for Hyderabad Karnataka region order 2013. This is the
wide
end.
ಇದೆ.
That clause 2 is wide enough.
But even otherwise, apex court said in two decisions, the items in the allocation of business or transaction of business should be widely interpreted and hold ಮಾಡಿದ್ರು. One matter arose from Karnataka.
It is, it should not be given a very constricted meaning. To that extent, I have no difficulty.
But even otherwise also, the
But-
second
But
item,
when service rules, making of service rules is governed by a special instrument. That is legislative edict, Karnataka State Civil Services Act. Whether that could be brought under this is something that requires to be examined. Because section 3 of the 3(1) of the
78 Act.
Karnataka 78 Act clearly says all matters regarding recruitment, conditions of service, everything. Therefore, there is no scope for interpretation. It is very widely overrated. It includes everything, including the recruitment.
In other words, what you want to say, because of the absence of the word notwithstanding
Yes, ma'am.
in 371, which
Yes,
is
ma'am.
conspicuously absent and conspicuously present in rest of the
The
provisions.
creation of 371J cannot say notwithstanding. Because parent itself is notwithstanding,
That-
lacks that overriding power. It will have to be done in the manner that is provided in the ordinary law, that is Karnataka State Civil Services Act.
Ignoring the non-obstant, the overriding clause
Because, my
in
lords,
governors this one.
when 371J itself does not have overriding power,
The delegate cannot make it wider than what the delegator did it.
it reminds me of, my lords, formation of ICICI Bank. Normally, my lords, it is the child which joins the family of the parent. That is a lone exception in our Indian banking industry, banking history, where parent merged into the child. That is ICICI Limited was an internationally reputed development finance institution in this country. That merges into ICICI Bank. I personally feel, maybe, my lords, I am old valued. In those values, my lords, it must have been a unit of ICICI Limited, and this is somehow not keeping with our.
If that circular goes, suppose Mr. Phadke's challenge succeeds, what would be the effect?
Even then, my lords, my argument that changing the norms after the commencement of recruitment, that would, after publication of the provisional list, that would remain. Because the notification was issued and in the application stipulated, by application that was provided in that recruitment notification, this option clause was there very much. Whether it is traceable to 5/5/2012, to 1/6/2020 or not, that is irrelevant. And on that basis, we applied, because technically there were 40 options for us. 34 districts, in each 2 cadres, 68 cadres we could have applied. Because of this particular option, we chose a particular cadre. Here my chances are brightest. Because in this area, the contest or the competing candidates will be such that I will be able to come within the cutoff or within the required merit ranking. I make that choice. And I get selected. Provisional list is published.
At that length of time?
After the provisional list is published, this impugned circular is issued, making it retrospective, applicable to ongoing recruitment also. I could have understood, my lord, suppose the moment the recruitment notification came, somebody came and challenged it, saying that this option is obnoxious and contrary to reservation order, or whatever it is. It affects my right. Therefore, no question of option. I should be in a position to compete as a candidate, both for residual parent cadre and also the local cadre. If such a challenge had been raised at the threshold, that is different. Here, the challenge to the circular comes after I challenge this 1/2/2023. Now, my lords, now I challenge 1/2/2023 on the most simple ground that is available to me is that you have changed the eligibility norms after playing out the game and I get selected. What remained was only a formality that if what I have stated in my application form, including my claim for reservations, my academic marks cards, if they are true, I could not have been thrown out. The only reason on which I could have been thrown out of the provisional select list is an arithmetical error of omitting somebody more meritorious to me, or any defect in my credentials. These are the only two grounds on which I could have been sent out. Now, by this instrument issued by the state, what is done is, persons who had not applied for that post are becoming eligible, because originally they applied only for the local cadre. Then the circular comes. Whether they have applied or not, the moment they are local persons, consider them first for RPC. And then only those who have applied for RPC. This is draconian in its operation. Therefore, it could not have been issued after the game has been played out, barring the last whistle to be blown. Everything else had been completed. Therefore, my lords, advisedly, when this 15/6/2022 notification was issued, it said that it will not apply to ongoing recruitment processes. This was already ongoing recruitment process by then. Then this 1/2/2023 is issued saying that if they had given a reason that this is contrary to Article 371J, contrary to the reservation, those are not the reasons given. Two reasons given is that local people's representatives have expressed dissatisfaction. Local candidates have expressed dissatisfaction. Local candidate cannot be dissatisfied because it was their choice. And their action is not questioning the recruitment notification. Local representatives, my lords, yes, they can have grievance. But for them, they have to vent their feelings in the legislature and not in the midst of a recruitment process. The two reasons given is, both are legally untenable for the reason that candidates who have willingly participated in the recruitment process, they cannot have a grievance. The local people's representatives, they cannot say, yes, so many people will be dissatisfied. There can be no service rule which can be satisfactory to everybody. That is what Supreme Court said in vide consort in the matter of Reserve Bank of India. That is the shortest ground that is available to us, irrespective of what happens to the circuit. Okay. And then, my lords, even assuming they have a power to remove difficulties and all that, power to issue clarification, this is neither of the two.
Go to 423.
Yes, ma'am.
Removal of doubts.
For the removal of doubts, it is hereby nothing in this shall affect the operation of any provisions made by the state government or other competent authority by or under any law before or after commencement in respect of reservation in the matter of appointments of posts in favor of persons belonging to backward class of citizens, scheduled caste, scheduled
Only
tribe.
SC.
This is my lord's,
This
this is,
ಇದೇನು apply ಆಗೋದಿಲ್ಲ ನಿಮ್ಗೆ.
it will not apply because it deals with the vertical reservations and horizontal reservations provided under the general recruitment rules.
ಅಲ್ಲ ಅದು ದಿ ಅಬ್ಸೆನ್ಸ್ ಆಫ್ ನಾನ್ ಅಬ್ಸ್ಟಾಂಟೆ ಅದ್ರ ಇಂಪ್ಯಾಕ್ಟ್ ಏನು ಅಂತ ನೋಡ್ಬೇಕಾಗ್ತದೆ. ಮೋಸ್ಟ್ಲಿ ಅದರಲ್ಲೂ ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ ಅದು.
ಇದು
ಯಾಕಂದ್ರೆ ಅದು ಯಾಕೆ ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಬೇರೆಲ್ಲ ಆ ವರ್ಡ್ ಇದ್ಬಿಟ್ಟದೆ. ಹಂಗಾಗಿ ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ ಅದು.
My
371A is already upheld by this court.
Correct.
that is upheld.
We are not on that. Yes. What is done under 371?
Because 371J, if it is not having overriding effect, it is subject to ordinary service jurisprudence.
Because of conspicuous absence of that.
Absence of that. And ordinary service jurisprudence tells us
Will be applicable to that.
will be applicable, and that says that you cannot change the rules of the game. Rules of the game, what is rules of the game? That is
We are asking one more question.
Yes.
Suppose the effect to this article cannot be given effect to the true intent of this article cannot be given effect to unless we read into that article non-obstante.
That
Is
would
it
be,
permissible
that would
to
be
us?
rewriting the constitution, which is not permissible in a judicial.
Otherwise, it will be dead letter.
My lords, when the parliament made this, it was aware that it is subject to all other laws. Otherwise, 370 to 371I, if they have used that notwithstanding,
Only in this article.
only in this article it is omitted. It cannot be taken as causus omissus. It is a deliberate omission, well thought out omission. Perhaps my lords, the parliament might have felt that the area for which we are making this special provision is not as backward or as ill-served as the areas for which we have made special provisions in other genre. A lesser remedy would be sufficient for this region. A lesser special treatment, my lords, after all, special treatment. Some people are given extremely high special treatment. That was 370. Then 371 various clauses gave some sort
But
of.
our question remains unanswered.
Yeah,
We are asking you.
I am.
Suppose if intent of this provision cannot be effectuated unless we read into it non-obstante.
My lords may not.
Can we do it or not?
My lords cannot read it, is my humble
We
submission.
should just simply construe it. leave it
Simply
as it.
construe it, because we do not make the laws, we interpret the law.
Sometimes we make also.
Sometimes my lords may remove, my lords. My lord's power is to remove the.
Professor Rajiv Dhawan said, the Supreme Court is a constituent assembly in continuous session.
That's not, in fact, not this question came in that 7-judge judgment in Antules case. Because 5 judges had held that he shall be tried by a special court, which is the High Court. That was challenged when charges were to be framed pursuant to that order. In that, my lords, 7 judges, Supreme Court said that we do not make law. We only declare law.
ಆ ಕೇಸ್ನಲ್ಲಿ
ಆ ಕೇಸ್
ನಾವು ಯಾವಾಗೂ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿದೆವು.
ಅಲ್ಲ ಅವೆಲ್ಲ ಮಾಡಬಾರ್ದು ಅಂತಲೇ ಹೇಳಿದ್ದು. In fact, if the lords would read the entire judgment, it gives an impression that we are not constituent assembly, nor are we the parliament.
ಹಂಗಾರೆ ನಾವು ಸ್ಟ್ರೈಕ್ ಡೌನು ಮಾಡಬಾರ್ದು ಯಾವ ಲಾನು.
Law of
Striking down is also repeal of law.
No, my lord, striking down is because it offends the constitution. Because constitution.
That we was there, even Lord Coke did not agree when King said that to him. You are only to interpret what the laws I make. He said, no, it's not, that's not the way. But how we can agree with that? We are also in a way sharers of constitutional power. We are constitutional institution and we have not accepted the strict doctrine of separation of powers. We exercise some legislative power, legislature exercises some executive power, executive does some legislative power. This we never treated Montesquieu with that height.
My lord, sir, without going into that principle of separation of powers, whether they are strictly applicable here or not, insofar as Constitution is concerned, the court cannot read a very significant addition to the text. Because if something is made subject to ordinary or all other provisions of the Constitution, my lord, should not be within the limits of judicial review. If my lord should change the architecture of that article, because by reading notwithstanding into it, my lords would be substituting the structure and architecture of that provision, which cannot be done.
All right, next date on standard books of like Grace, Sutherland, Maxwell, ಇವನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡು ಹೇಳಿ. In the absence, whether notwithstanding, non-obstante clause is read into by the courts, by colonial courts, Scandinavian courts, how they have.
My lords can remove the creases, nothing more than that. And reading notwithstanding may not be.
But there are some.
I would, because
when we say,
there would be
further research, because we say it after reading. Otherwise, we'll call the book to show it to you.
No, I am grateful, my lord, that
there is one judgment, Lord Denning. He said, where a particular situation is encountered by the judges, for which answer is not found in the pages of statute, the
they cannot
should
hold
do.
our hands.
No, he said, judges should do what the parliament would have done. House of Lords overturned that judgment, reversed that judgment. But we have accepted Denning's view, at least in three judgments. In three judgments we have done. We cannot say legislature has not provided. And after all, it is the parliament which amends the constitution. Regardless of whether constituent power, legislative power is another thing. It is parliament which amends the constitution. We don't constitute another constituent assembly to amend the constitution.
The question is this, my lords,
Therefore,
whether judiciary can amend the constitution.
not
Because the word my lords are suggesting would be amounting to amending 371J.
we have done that. For example, directive principles of state policy. They say first article in directive principles, state policy said, these are non-justiciable. But we have given justiciability.
Over a period of time, we have said
Anyway,
that
anything begins from today.
what we have said in this, over the directive principles or not, they can be given if they can be directed to be implemented to give effect to the fundamental rights. There again, there also the Supreme Court has been very cautious. It said that by doing so, we will be effectuating the fundamental right.
But our judgment is there, which
I am not ruling out any possibility, my lords.
First article here. In fact, Dr. Ambedkar was very critical when T.T. Krishnamachari said they should be made justiciable. Dr. Ambedkar did not agree. That first article under that chapter, the part 4.
Part 4.
7.
Part 4, chapter 7.
Article 37.
Correct. It begins with 37. 37 says, the provisions of this chapter shall not be, this part shall not be justiciable. But see what we have done with that particle. Therefore, it is not that. Therefore we say, we are not the, ಮಡಿವಂತಿಕೆಯಿಂದ ಇದನ್ನ ನಾವು
ಇದರಲ್ಲಿ ಯಾವುದು
ಮಾತ್ರ ಅನ್ನೋದನ್ನ
my personal
necessary.
My personal philosophy towards the role of the judiciary is that we should be forward looking.
We should be
forward looking. And when we seek to ತಾವು ಇದು ಶುರು ಆಗೋ ಮುಂಚೆ we are lagging behind ಅಂತ ಹೇಳಿದ್ರೆ book old edition. We should be moving forward.
2018 ಕೊಟ್ಟಾರ ನಾವು ಅದನ್ನ ಓದ್ತಾ ಇದೀವಿ. ಅದು ಇಲ್ಲೇ ಇಲ್ಲ. ಅದಕ್ಕೆ ಅವ್ರಿಗೆ
We should move forward, move under when some progress of this society is required, certain tailoring of the law by the judiciary is permissible.
Not only tailoring, why are you so frugal in your views? We have legislated. What is Vishaka?
Vishaka Maharaj,
legislated.
that was in
not
the,
just
that
rendering
was
judgment.
in the absence of a legislative edict, and it's clearly said under Article 142.
Anyway, we are just
Vishaka
saying,
is 142.
when earlier we used to make law in the presidential sense of the term. But at least in 2 judgments, we have legislated.
But
Vishaka.
Vishaka is one, and
Now,
thereafter, my lord,
therefore, we are gradually, therefore it is said, the Indian judiciary, especially Supreme Court and the High Courts in the country, are the strongest judicial institutions in the world. In the world, even American Supreme Court has not done it. We have done that. Therefore, your view that we are only interpreters, we are only there to put our construction on statutes, that may not be true. That
but
may
it
not
may, but it is also, it may not also be true to say that you can change the structure and architecture.
That's right.
And by introducing that word notwithstanding, the entire structure, basis, architecture of that 371J will undergo such a change that it would not be like amending what they said in interpretation of amending power. It will be substituting.
So it will not serve the interest of your clients, we can say immediately.
No, not the clients. It will not be in the best traditions of constitutional law as evolved in this country.
ನೋಡ್ಕೊಂಡೆಂಕು ಬನ್ನಿ. ಅಲ್ಲಿ ಕ್ರಾಫರ್ಡ್, ಸದರ್ಲ್ಯಾಂಡ್, Grace on statutes, at least 3 books have referred to. They have referred to some judgments where courts have read notwithstanding or similar clauses in the statutes when the statutes were absent about them. Just ನೋಡ್ಕೊಂಬನ್ನಿ. ನೋಡೋಣ, we'll see. Okay. ಯಾವತ್ತು ಈಗ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದೆಲ್ಲ ನಾವು ಡೈಜೆಸ್ಟ್ ಮಾಡ್ಕೋಬೇಕು, ನಮ್ಗೆ ಒಂದ್ 2 ದಿವಸ.
ಅಲ್ಲ, ನನಗೆ ತಾವು ಸಫಿಷಿಯಂಟ್ ಕ್ವಶನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಐ ಹ್ಯಾವ್ ಟು
ಒಂದ್ 2 ದಿವಸ 3 ದಿವಸ ಬೇಕು. ನಿಮ್ದು ನೀವು ಹೇಳಿ ಯಾವ ಡೇಟ್ ಬೇಕು ಆ ಡೇಟ್.
ಐ ಹ್ಯಾವ್ ಟು ಲಾಟ್ಸ್ ಅಪ್ಲೈ.
But in a wholesale way, we will consider 371J.
After 20th.
20th?
After 20th.
ಹೇಳಿ ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ತೊಗೊಳ್ಳಿ.
21st or 22nd.
ನಡೀತಾ? ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಹಾಕೋಬಾರ್ದು. All right, thank you.
Lord, I will take back those home binding, my lord. Add, my lord, those 2-3
ಮಾಡಬೇಕು, ಇನ್ನೊಂದು ಮಾಡ್ಬೇಕು. ಅದಕ್ಕೆ ಇಂಡೆಕ್ಸ್ ಇಲ್ಲ.
ಇಲ್ಲ, ಹಾಕ್ಕೊಡ್ತೀನಿ.
ಒಂದು ಇಂಡೆಕ್ಸ್. So that immediately
that I will do it.
Share a copy with your friends.
Yes.
2:30.
21st, my lord.
21st, 2:30. ಬೇರೆ ಯಾವ್ದು ಹಾಕೋಬಾರ್ದು.
ಕೊಟ್ಬಿಡಿ, ಚೇಂಜ್ ಮಾಡಿ ಕೊಟ್ಬಿಡ್ತೀವಿ.